Yes, we're ready, yes.
Welcome back. It's 1:05 and we're ready to reconvene. Ms. Cicchetti, if you please call the next item.
Sure. The next item on the agenda is the item that we postponed. We're taking it out of order. Is item number 5. Board member matters and initiatives, Assessment Appeals Board, AAB, County Council Training Course. Report on AAB County Council Training Course submitted by Thomas R. Parker, Deputy County Council, Los Angeles County Council Office, to evaluate and consider possible suggestions regarding the AAB County Council Training Course submitted by Thomas R. Parker, Senior Deputy County Council, Los Angeles County Council's Office, and reviewed by the BoE Chief Counsel. Possible board actions. We have a couple of speakers for this item, but I see Mr. Parker is already on. Oh, yeah, there he is.
There he is.
Okay. So he's the first speaker we have.
You know, when we went out of order,
You were on page 29?
I'm not finding my number 29 here. Oh, here it is, okay. Members, we now open the hearing on Board of Equalization Assessment Appeals Board Council Training on Rules 301-326, authored by Mr. Thomas Parker and reviewed and approved by the BoE Chief Counsel Henry Nanjo. And Mr. Parker, I see you on the screen, will explain the training curriculum and answer questions in response to suggestions from the members and the county assessors, taxpayer representatives, and other stakeholders or interested parties. Our goal is to ensure that this training advances equity for all so that every party may receive an adequate, impartial hearing of any appeal regarding that property. As agreed, the board may determine the appropriate action relevant to any suggestions or input made after the close of the hearing. With that, let me have Mr. Parker open up with his remarks. Welcome.
Thank you, sir. Mr. Chair and honorable members of the State Board of Equalization, thank you for this opportunity to testify before you today. I first testified before the State Board this month, 25 years ago, and it remains an honor to do so today. My first observations relate to the recent letter submitted by KEDA to your board on this item. I thank KEDA for the kind words regarding the document, for myself personally, and for my county counsel's office. They are much appreciated. Speaking personally, I respectfully disagree with the legal assertion of KEDA in that letter that Revenue and Taxation Code Section 1624.02 governs this agenda item. Section 1624.02 specifically and exclusively deals with the preparation of official state board training for AAB panel members, not AAB councils, or any other party involved in AAB appeals. KEDA's letter seeks to expand the scope of this statute without any legal basis in the wording of Section 1624.02. If the state legislature had intended to apply the consultation process of the statute to the training of AAB councils, they would have so stated, and they know how to so state. It is also my understanding, hopefully correct, but I'm glad to be corrected if I'm wrong, that the state board is not currently authorized to provide legal training that receives MCLE training from the state bar. If I am correct in that understanding, AAB councils would not receive state bar MCLE training credit for state board presentation of the material I have drafted. The state board over many years has provided clear and useful guidance to persons involved in AAB appeals, both laypersons and attorneys. As the author of this document, I did not intend to and have not attempted to produce an all-inclusive discussion of the AAB rules or issues. Given the limited focus that I pursued and prepared, I do not personally believe that it is necessary to broaden the scope of the document, nor add further items to the document. Broadening the scope of the document will not add to the hoped-for clarity of the document as it currently appears. I also personally believe, but I'm not in any way attempting to be your counsel when I say this, that your board could approve this document as appropriately discussing and summarizing rules 301 to 326 today. The document could then be used by county AAB councils and the County Councils Association. I recommend that your board consult with your own counsel if you have questions regarding that observation. I am aware that Mr. Edward Yen of the Los Angeles County Executive Office, responsible for managing the county's AAB, will be testifying today and tomorrow on what the LA County Assessment Appeals Board, AAB, is doing to continually improve its operations. I am taking the liberty of adding my own personal observations of not only Los Angeles's operations, but operations of other counties over the past 29 years. Los Angeles County Council provides legal training on a quarterly basis, typically 4 to 5 items, to AAB members and hearing officers. The legal topics chosen are selected by the AAB based on questions presented to the AAB through appeals or requested by AAB members and hearing officers. The quarterly legal trainings are interactive with the attendees, and the 2 Los Angeles County Council AAB councils get many questions and comments and experience stories from the board members relating to those issues. And we address them all at the quarterly training, whether or not they were specifically slated for discussion in our presentation. County Council also provides what we colloquially call cold call requests for legal advice from panel hearing boards at any point during the appeal hearings themselves. Having worked for 5 counties of varying size and resources for 29 years in property tax, I can tell you from my own experience that the Los Angeles County Assessment Appeals Board and its managing executive office is the most resilient, the COVID period being a prime example, and responsive provider of AAB property tax hearing services to the public and taxpayers filing appeals, in my experience. I am glad to field any questions the board may have, obviously, and I thank you for your time on this matter and the opportunity to speak to you today.
Thank you. With that, I guess before we get into questions, so we have Ms. Chiquette, should we bring the panel up, I guess, from,
Yes. If you'd like to, I
I
can-
guess we're gonna have 3. I see Mark,
Mark.
Craig, and Mr. Waldman, right?
Craig,
you would-
we have Mark Caprea, Craig Becker, and Paul Waldman. Would you please come forward? Thank you.
Do Do we have somebody else waiting on the line?
Eddie N., which is later on. He's going to make a presentation later on.
Oh, okay.
Unless you'd like to have him now to participate, that's fine.
Is he part of the presentation with Tom Parker, or is it?
He is, he's part of the agenda, yes.
No, but I mean, is he tied into the same, he's not from the same,
No,
I want to say department, right?
no.
Okay. All right, well, why don't we go with the panel? It looks like he's okay on hold there. Okay. Welcome.
Mr. Chair, members of the Board of Equalization, for the record, I'm Mark Aprea with the firm of Aprea and McKaylee, and I'm here on behalf of the California Alliance of Taxpayer Advocates. I want to thank the chair, the board members, and staff for allowing us the opportunity to testify before this board today. I want to identify that the agenda for the August 29, 2023 BoE meeting drew the attention of the CADA board, specifically the notice of then item number 9, the Assessment Appeals Board County Council Training Course. When we looked at that item, there was a notice that included, Mr. Chair, your memo to your colleagues on the board. But when we clicked on the link, there was no attachment. There was the document that Mr. Parker prepared was not there. And so we waited for that to appear coming into this meeting. And in your August 18 memo that we saw, it says here, and this is coming from you, Mr. Chair, I am proposing that we tentatively schedule a full hearing to allow public input and discussion with all county assessors and stakeholders at our next regularly scheduled board meeting on September 26, 27, 2023, and that in preparation for that hearing, each of our offices review the course and propose any suggestions at that time. The board may determine appropriate action relative to any suggestions or input made after the close of the hearing. Upon final approval, the publication by the board, the course will be made available to county tax councils throughout the County Councils Association of California for their use and reference. The link on the August 29 agenda contained this memo, as I indicated, but it did not include the State Board of Equalization, Assessment Appeals Board, Council training on State Board Rules 301 through 326 as prepared by Mr. Parker. Now, we want to commend Mr. Parker and the BoE for engaging in preparing and vetting this document. We also want to commend the BoE for its leadership in this effort. This is precisely the kind of leadership that is needed to ensure that there is consistency of assessment and assessment appeals board practices across the state. On Thursday, September 14, in advance of the agenda for this meeting being published, we spoke with staff and brought to their attention that the prior agenda did not include Mr. Parker's compendium. Further, that we indicated that was, and requested that. BoE staff then sent us that compendium, and that is what prompted our letter dated September 22. In our review of this compendium on Thursday, September 21, I also spoke with Rob Gutierrez, President and CEO of the California Taxpayers Association. In the course of that conversation, he went to the BoE website. He too did not find the compendium on the BoE website. He could not be here today, but asked me to share with you that Caltax shares CADA's views on this matter as expressed in our letter of September 22. We suggest that the BoE not only satisfy the requirements of section 1624.02, but we also ask that this board look at the fact that this matter has not been properly vetted, nor has there been the opportunity for people or interested parties, particularly those who focus in on property tax matters, to take a look at this. We're not suggesting that you not proceed forward with this version or some alternative version, but rather that we have not been afforded the opportunity for sufficient review and comment, and therefore are asking this board to provide that opportunity by either taking the current assessment appeals working group and making this part of that process, or creating a working group that can review this material, address any matters that are appropriate, and that this matter then come back to the board for final review and approval. With me today is Craig Becker, a partner in the firm of Pillsbury, Winthrop, Shaw, Pittman, who serves as Vice President of CADA. Also joining us is Paul Waldman, a director at Ryan, and is a past president of CADA. Craig?
Well, thank you. Thank you, board members, for giving us the opportunity today and scheduling this public comment process, scheduling this hearing. As we all know, probably one of the principal functions of the Board of Equalization, if not the principal function, is oversight of the California property tax system. And it's provision of oversight, technical support, letters to the assessor, rulings, and obviously training material too is the critical function of what the Board of Equalization does, and why all of you as elected officials are so important to the property tax system. You ensure that all the stakeholders are heard: assessors, taxpayers, county board of supervisors, assessment appeals board administrators. This is the forum for all of us to be heard. And your job as elected officials, making sure that happens, which you all perform so well, we're so very appreciative for, and thank you for the hearing today. The training material that we're talking today, training material for Assessment Appeals Board Counsel, I think is a particularly important sweet spot for that activity. Because as we all know, the Assessment Appeals Board, the local assessment appeals boards, are the people who issue decisions for disagreements between assessors and taxpayers. And thankfully, we we all hope they're minimal and they all get resolved. But occasionally, we have assessment appeals board hearings where those disagreements need to be resolved. And it's a quasi-judicial body. It actually acts as a quasi-judicial decision maker with great deference given on appeals. So it's a really, really important body. The training to appeals board counsel is particularly important, not only because of this important body, but because appeals boards are oftentimes community volunteers. They're brokers, they're CPAs, they're people taking time out of their busy professional careers to provide an important community service. And thankfully they do that. We really appreciate that. Occasionally we have a lawyer on the board, but my point is that all these board members, oftentimes, they're not superior court judges. And the advice and support of appeals board counsel in carrying out their duties is critically important. That's the source of legal information and legal background that contributes so very much to the quality of those decisions. And so the training material that is issued to provide that is so critically important. And we applaud Mr. Parker in working so hard on his compendium of the rules, but I think it's really important that training material be given great consideration and be well vetted by all sides. And again, we appreciate the opportunity, both the hard work of this board in making this meeting available today, and also the very hard work of County Counsel Tom Parker, very respected. As we all know, Mr. Parker's been doing this a long time, and he's very, very good at it. CADA's objective in all of this is not to hinder or slow down the process, but to hopefully be helpful. And so that's our first and most important thing. We want to be helpful here. We want to be helpful in helping all of us address the needs and concerns of all the stakeholders. And what, as Mark said, that the challenge that we see at this point is that approving this document today would be inopportune because it hasn't had the opportunity to be publicly vetted. As Mark notes, it just hasn't been publicly available, and as Mark also notes, in talking with other organizations, our own members, as well as other members, CalTax, other taxing agencies. Nobody's had the opportunity to fully review it. We've only had it in our possession for a very short period of time. And so we think it would be a better decision not to approve it as the state board's official training materials at this point and give it that seal of approval, but instead allow an opportunity to have it be more fully vetted by having it be more publicly, having a period for public availability. Again, I see several reasons why this is a good idea. First of all, as we said, Mr. Parker's work is excellent, but we believe it's always, when I write a memo, when all of us write memos as good lawyers, we always find benefit from having other good lawyers, other good authorities review it and look at it, and nobody's really on the taxpayer side has had the opportunity to do that yet. Even if there were no comments, even if it was minimal, we would expect this is also important because there will likely be more training materials. I mean, this is just rules 301 to 326. There will likely be additional materials that come down the pike for not only Appeals Board Counsel, but also Appeals Board in general. And we think it would be a good idea to develop a working group process where the board has a more formal process to see that approved and vetted and reviewed by everybody so that all stakeholders can see it. We see many things in the Constitution, the statutes, that require that all stakeholders be included. You can point to the Government Code 15606, and we pointed to 1624.02. I respect Mr. Parker's view that 1624.02 does not specifically say Appeals Board Counsel. It says Appeals Board members. We respectfully make the claim that Appeals Board Counsel are at least as important as the Appeals Board members in this process, and that 1624.02, even if you conclude that the exact language of it doesn't apply here, the spirit certainly applies. And the spirit of it certainly applies with respect to what this board does in general, which is the good work it does promoting the review and input of all stakeholders. And so our view is that good government implies that we should follow the dictates of what's in the Constitution, the Government Code, all of the provisions that say that this should be an inclusive process where all stakeholders get an opportunity. And at this point, all the stakeholders have not gotten an opportunity, and we believe it would be much better for the board to defer approving this today, give more opportunity for us all to have an opportunity to review the materials, and also just to create a process where the review of future materials like this for the important function Appeals Board training for both council and board members of Appeals Boards has a working group process so it can be more completely vetted by all the stakeholders, assessors, taxpayers, administrators, just like Section 1624.02 states. And thank you.
Thank you.
Members of the board, thank you again for the time. We appreciate that. And I think Messrs. Aprea and Becker really stated our position quite thoroughly. I just want to make a couple of emphasis that Mr. Parker again, and I want to reiterate what they have said, is he's done a terrific job here, and we appreciate the work he's doing. And this isn't necessarily a complaint in what he has produced or that he is producing it. Again, it's just a matter of we believe that it would benefit from the process of a public vetting and more stakeholders reviewing this. Tom Parker respectfully says 1624.02 doesn't really apply here. But at a minimum, would it not still be a better process to go through this? Is there any reason not to? Really, is another way to look at this. Is there a particular rush to get this thing approved right now? Is there any reason not to have additional stakeholders look at this and say and offer alternative viewpoints? He does mention too that the county council trains the AAB members quarterly on legal issues, right? And so this indirectly does go to the board members. So I think there's an argument there if you're trying to argue against 1624.02. But that's just the bottom line, is that we feel that this process, it feels a bit rushed to us, and we feel that it would benefit from a working group or some type of a process where all the stakeholders get to at least see this and offer their point of view on it and whether there might be some ways to possibly improve this or correct any errors or issues that might be found in the process. So that's what I just wanted to kind of emphasize those last points, and I think that's all I have to say. Thank you.
Thank you. Mr. Kenny, I know we have others, I don't know if they're in the queue, that also want to weigh in on this before I bring it back to the board here for discussion.
Okay, we have Mr. Yen, who is going to make a presentation, and then we have Christine Lee. She's the president of the California Assessors Association, and they're both on our hybrid, so we could ask them to participate if you'd like.
Why don't we do that since they're sitting in their, they're already queued in here. Who
Hi,
wants
good
to go
afternoon.
first? Go ahead, Mr. Yen.
Okay, I do have a presentation,
Sure.
and I believe your
We're gonna-
office is going to be presenting.
The presentation was going to, if you wanted to do it now, the presentation, or if you wanted to. Excuse me.
Yes, my
Mr.
speaking points are, my talking points are directed towards the presentation,
Okay, thank you.
Just before we get started, though, I think my vice chair had a question here.
unless you want to hold off on my presentation.
What, give me a second here. Go ahead, vice chair.
Well, I have questions about the direction that we're taking, and what I
Okay.
understand about Mr.
I'll proceed.
Yen's presentation is it's
Good
more-
afternoon, members of the Board of Equalization.
darn.
I want to start by thanking the chair,
Hold-
Board Member
hold-
Vasquez,
Can
for
you hear me?
providing the Los Angeles County's Assessment Appeals Board this
know if you
opportunity
can
to
hear me.
showcase its Assessment Appeals Board training curriculum.
Mr. Yen, can you
So
hold
just a
on
little
one second?
background about myself. Prior to working for the
quite sure
Assessment
you can
Appeals
hear
Board
us.
and overseeing it at Los
Mr.
Angeles
Yen?
County.
Can you
Oh,
hold on one
yes.
second, please?
Sure.
Ms. Lieber was making a statement, so if you could hold off on your presentation for a minute.
Thank you. So my question, my understanding of what Mr. Yen has to present to us is around implementation of the product of this discussion. But I did have a couple of questions about the process. And I don't know if those would be good to talk about at this point, before we kind of go full bore into the implementation of a product. Would that be a good time for this
Sure,
right now?
absolutely.
Sure,
Mr.
let's
Chair,
do it,
if I
let's do
may.
it.
So my understanding when this has been before us was that Mr. Parker was launched on a product, a process of developing his product for the county councils and the Assessment Appeals Board councils. And that he wanted permission from us to have our legal team do a review of what he produced to see if it was a faithful communication of particular code sections. And so I guess I didn't have it in my mind when we came up to this meeting that it was going to be considered a publication of the BoE, because my supposition would be that if we were going to develop rules, that we would put out an RFP, sign a contract with a law firm or whoever to draft those potential rules, or maybe it would be done in-house. And then we would go through the full process that 1624.02 would dictate. And that our role with Mr. Parker's product was to give it a light review and to see if it was congruent with what our understanding is of the code sections. And in the agenda report that we got today, it says final approval and publication by the board. The course will be made available to county tax councils through the County Councils Association for their use and reference. So they would continue to be the owners of the intellectual property, and it didn't seem to me like we had a role in terms of that that we would be the entity that would be publishing it if it belongs to someone else. Can you help us find our way out of that?
Absolutely. Thank you very much for that discussion and line of questions, Vice Chair Lieber. Chairman Vasquez, Vice Chair Lieber, members of the board, Henry Nanjo, Chief Counsel. So let me start back with how this came to us. So if you remember correctly, Tom Parker came and said that he was willing to put together some training for AAB Council. What he requested through the chair was that both Property Tax Department and BoE Legal take a look at it and just let them know if there's any red flags. This is not, at least in my mind, a BoE product. This is Tom Parker's product for potential use with the County Councils Association, and we were more giving him advice, a courtesy look through to see if there was anything that we objected to or any suggestions we would make. So that's kind of the context in which this came up. As far as the training itself, I tend to concur with Tom Parker that 1624.02 does not apply in this case because this is not board training. As you know, we do have a course for AABs. That has gone through the 1624 process. That's been fully vetted, and that's the only course that we as BoE offer. When Tom Parker spoke to me about his idea, it was a little bit different, and one of the issues that he raised in his comments, which is absolutely correct and we discussed, was that county councils have to do mandatory continuing legal education to keep their state bar license active. And along those lines, for that to count, it has to be given by a state bar certified MCLE provider. Unfortunately, we are not a state bar certified MCLE provider, which is why for the county councils to be able to take advantage of getting MCLE credits for this, we would not be the ones teaching this. So this would be something that either Tom Parker teaches himself, or he, in conjunction with the County Councils Association, they have somebody in their own system that they teaches, because if I'm not mistaken, I believe the County Councils Association is a certified MCLE provider. So from the standpoint of the department, what our position has been, again, we're happy to cooperate, we're happy to assist, we're happy to give our comments, but that's what we did. Now, insofar as the board, Chairman Vasquez, I think, had an idea that, maybe if this is something that everyone agrees to, we can maybe link to it in our on our website or the board materials, and just make it available. But again, I want to be clear from a legal standpoint. I don't want to take credit for somebody else's work, among other things. So this would not be a board product or board training. It would always be either Tom Parker or county councils, if they adopted it, their training. So,
A follow-up question, if I might. So say that we receive input from an entity, anyone, and we say that Mr. Parker's materials, I assume that it's owned by him, do we have the right to change his owned products?
I would be very hesitant to do that because it is his product. And that's one of the things that I wanted the board to be aware of, is if the board was going to do training, whether it be to AAB, to property tax petitioners, assessors, appraisers, whatever, we have our own process that we go through and we do to develop training. We develop them generally in-house. We don't contract out. And we have a set of people that we consult check with colleagues, that sort of stuff. And then we do a process where, very similar to 1624, in some cases 1624 process, where we do have CADA and other stakeholders participate, give comments, and not the least of which, another component of that, I'm sure the board members remember, is we work very closely with the CAA Education Committee. We get their input. So there is a whole long process that we do for board training. Board approved, board sponsored, board issued training, if you will. This is kind of a one-off, if I can use that term, and it's something that a community practitioner, Mr. Parker, came and said, hey, I'd like to do this. I think this would be good. Do you have any problems looking at it? And we said no, of course. So that's kind of in a different vein. If you were to collect comments on Mr. Parker's materials, I would say the appropriate place is whatever comments are made, turn that back over to Mr. Parker, and it's up to him to whether he takes those comments and makes changes or not.
Okay, thank you.
Mr. Chair, may I respond to Ms. Lieber's questions?
Sure, go ahead.
I want to point out the August 18 memo from Chairman Vasquez to his colleagues. And I want to point out that there is an expectation that the board is going to take in public input and make a decision. Let me read it, if I may. I am proposing that we tentatively schedule a full hearing to allow public input and discussion with all county assessors and stakeholders at our next regularly scheduled board meeting on September 26, 23. The memo goes on, the board may determine appropriate action relevant to any suggestions or input made after the close of the hearing. The last comment, upon final approval and publication by the board, that is the BoE, the course will be made available to county council. So there's been an expectation that this matter is going to be brought here, that there will be an opportunity for public comment. I have testified and in my conversations with staff, but other stakeholders, and I'm not looking to find fault. Things happen. But there were occasions when we went to your website to see the content that Mr. Parker had provided, and it was not there. In fact, there was on one occasion, this was at the end of last week, when for this agenda item, there was no link at all. And so what we are suggesting here is that you have created an expectation that there will be an opportunity for public input, that you all will take in that public input, that you will make a decision, and that you will take a vote on what to do. We are simply asking that the opportunity for that public input was not there, that the expectation that was created has not been satisfied, and again, not suggesting for a moment any purposeful action, but that expectation has not been fulfilled, and that we would like to have the opportunity, as well as Caltex, to take a review of this material. I'm not suggesting that there is anything wrong or inappropriate in Mr. Parker's work, but given that this is going to be submitted to all county council and provide them an opportunity, and it will have, if adopted by the BoE, the BoE's Good Housekeeping seal of approval, that there's a certain weight that county council will transfer to this document, that they can now use this, and that it is in fact an official BoE document. Whether that is appropriate or intended or not, that's the expectation that was created by this memo from the chair to the board members.
And that same language was in the September 15th letter immediately before this hearing was scheduled, that this would lead to final approval and publication by the board. Yeah.
No, you're correct. There's a follow-up question real quick.
So I have a follow-up question again for Mr. Nanjo. Do we have experience, like in terms of linking on the website, say that we link to a particular author's material, and then that author decides to take down that material, to amend that material, and those amendments might include some fault. But do we routinely link to material that we have no possession of?
Generally speaking, no, I don't believe we have. Mr. Young can correct me, or Mr. Kim can correct me if I'm wrong, but generally speaking, the only materials we tend to link to are either our materials, or if we're requested as a courtesy for CAA or the Assessors Association may have a form or something that we would link. I don't know if we've done that before or not, but that would be the only exception. Also, if I can ask board proceedings, I've heard a couple times from Kata and that Mr. Parker's document was not linked. I wanted to ask either Kathy or Mary to verify that, because I could have sworn it was linked earlier.
Yes, it was linked on August 21st for the first time for the August meeting, and then it was linked again on the 21st of September.
Okay, that was my understanding, so I'm not sure why Kata had problems locating that particular document, because it was part of the PAN and on our website as I know it. So, again, there might have been some confusion in the way Chairman, all due respect, Chairman Vasquez's memo was worded, but we don't really have a practice of having not board created, board-sponsored, the system that's gone through the full board approval system as approved training for us. Again, from legal standpoint, and I apologize if I misunderstood, I took this as an assignment to just let Mr. Parker know if we had any objections, if we had any suggestions, but I've always viewed this as his material, so.
Just a quick question. Wasn't it always intended to go to the County Councils Association, as we've noted here in both of these letters? I mean, it seems like it was intended to be offered for approval by the board, publication by the board, to be used by the County Councils Association, to be used on a statewide basis.
Excuse me, Mr. Chair, if I could ask about the rules, do we have a colloquy between
My apologies. I will hold it.
witnesses and staff where we don't usually experience that? Thank you.
Member Gaines, I think Member Gaines had a question or a comment.
Well, it's the memo that we sent out, and the memo indicated we take input. So I don't know if we're taking input from the
Is your mic
public-
on?
Yeah, it's on.
Okay,
Sorry, I'll speak into it better.
there you go.
But I don't understand why we're not taking input from CATA or any other entity in reference to this training program, if that's the way we laid it out in our memo. And so, just in my opinion, it seems to me that we ought to be taking that input, and I would slow the process down so that if there's any other parties that wanted to bring this forward, or any questions or any additions or edits they might want to make, and then at that point, we can make a decision as a board in terms of what to do.
Well, I mean, if I can respond, Member Gaines, Chair Vasquez,
Yes.
Vice Chair, members. The challenge here is we're doing something that we haven't done before, which is we're taking somebody
Somebody
else's
else's.
product and we're either adopting it in part or in whole. And we really don't have a process to do that. So that would be something that we'd want to look at. I mean, one of the inquiries I would have is, we have one course already. Are we talking about this supplementing that course? Are we talking about this being in addition to that course? Are we talking about this being added to that course? And again, as I mentioned, we have a process by which we do that already. Because Mr. Parker, and again, I'm not faulting Mr. Parker, volunteered to present this material to us and asked us for our input, it kind of came at us out of left field, for lack of a better term. At this point, the question is, how does the board want to handle this purpose, this product? At a very first level or easy level, we can just say, we don't have any objections to it. Mr. Parker, feel free to do what you want with it, and it's Mr. Parker's product, and he can do something with it. If the intent is for the board to somehow make this as part of its training materials or training cadre, then I would recommend that you bring Mr. Young up or talk to property tax and see how this fits into our original training, or our existing training, I should say. The other challenge with it, like I said, is we already have a process, and one of the first stops, as I understand, once we determine that we want to do some education or training or what have you, is we touch base with CAA's education committee and get their input, and that hasn't been done in this process. So I think what I'm trying to say is things are a little bit out of sequence. So we may want to kind of take a pause and have some discussions about how we really want to use these training materials, or whether we just want to say, thank you, Mr. Parker, good luck, do whatever you want with it, and what have you, so.
No, I think you're bringing up some good points, and I know when we first talked about this a few months back, I know the frustration, at least on my part, was we were kind of stuck.
Yep.
And he volunteered, and that's when Tom came up and he says, well, you know what, let me take a crack at it. And that's where it kind of evolved. And in the process, I thought all the stakeholders were informed or up to speed, or at least had an opportunity to look at this. And now what I'm hearing, for at least from some, that for whatever reasons, they weren't able to, whatever happened, I guess, when they were trying to link into it, weren't able to download it or connect to it. And then others that for some reason weren't even aware that it was even available, at least what I'm hearing from some, or at least our office has been called from others that are not even here today. I thought, well, we're scheduled to go forward with this. Let's hear everybody out, and then we on the board will make a decision what we want to do with it. And I think you're right on point. We're breaking new ground. This has never happened. And I think that was part of the issue when we first discussed this, because at the end of the day, like you said, legally, we don't own this.
Right.
It's created by a third party. We may want to adopt it, I think was the discussion early on, if it made sense, and if we had all the stakeholders that we've been working with on this issue on board and think it's a tool that could be used.
So if I may make a suggestion, obviously you can do a number of things, but one of the things you can do is say, to the extent Tom Parker wants to use this for his purposes, he's free to do that.
Right.
If you want to consider possibly adding this to BoE sponsored or approved training, what I would recommend is, one, talk to Mr. Parker, make sure he doesn't have an objection of us hijacking his materials.
Right.
But assuming that he doesn't have objections to that, then maybe property tax and legal can look at it to see how it may fit into our training, whether it would be a supplement, whether it be additional, and kind of do an evaluation that way. Because candidly, and I'm speaking for Dave, and he can correct me if I'm misstating this, but legal and property tax looked at Mr. Parker's training simply from the standpoint of, do we have any objections? Do we see anything wrong with it? And our answer to that was no. But whether or not this training is necessary, it'd be good to add to our training or be another course, we haven't done that evaluation yet. Am I correct, sir?
You are absolutely correct. Thank you very much. David Young, Deputy Director of the Property Tax Department. Thank you for this opportunity. Mr. Henry Nanjo, you are correct. When we looked at it, it was absolutely in the frame that Mr. Henry Nanjo framed it as. We were looking to see if there's anything there we would object to, and we under the understanding that it was Mr. Parker's property, and we were just reviewing it for him. So, as to whether we want to add it to our official training, Section 1604. Excuse me.
1624.02.
02.
Yeah.
There is a process to it, so we would have to consult other stakeholders in that too. So,
Mr. Chair?
Sure, go ahead. Member Gaines, and we'll come back. Go ahead.
If I could, and just a comment, because, so I think we provide services for folks that may have a legal question. They'll pose questions and we'll give a legal response. And in a way, what you're kind of describing is that is what you've done. But then we sent a memo saying that this would be a public hearing and we'd be taking input and comments. And so it seems to me that we're kind of at cross purposes, and it's got to be one or the other. But why would it come to us for approval if you're just vetting it from a legal standpoint, like you would any other applicant that would pose a question to you?
I don't know the full history on this. As you may remember, Mr. Parker, I think, approached Chairman Vasquez. That's part of, I'm not sure what the nature of the conversation between Mr. Parker and Mr. Parker and Chairman Vasquez's office was. From our standpoint, BOE legal, we just wanted, we were asked to take a look at it, say if we had any objections, and that's what we did. Sorry to play the attorney card, but the other thing as chief counsel I'd be concerned about is I would caution the board to just adopt what somebody else has done. If we're providing training, if we're even linking to training, we're responsible for that training. We're kind of liable for that training. So we'd want to make sure if the ultimate intent of the board is to have this as potentially board-sponsored or board-approved training, we would want to go through the full vetting process that we normally do for anything like that.
Wonderful, okay.
Yeah.
Well, I want to thank Mr. Parker for all this effort, and really grateful for it. I'm just trying to figure out how do we handle it as a board.
Yeah.
And I'd like to hear through the chair if we could.
Well, what I was thinking is that, since we did put it out there and the memo, like, has been stated already, was out to hear from all the stakeholders, and it sounds like we're missing a few still. If it's the will of the board, I was hoping that let's hear from those that are here. I know we have some people on the line. And then I would suggest or recommend that we continue this thing to continue hearing from other folks. Because at the end of the day, at least from the legal, it sounds like even if we wanted to, we couldn't adopt this today because it's not legal. Well, first of all, it's not even ours.
Right.
Right? We asked, like I asked my office, we asked Tom to produce this. He went above and beyond and produced something for us. And now I think to be respectful of that, let's take a look at it, get all the stakeholders to look at it, and if it makes sense, then I think we could turn around and pitch it to our staff and see where it may fit into our current training programs as they exist today.
Yeah, and just in, Chairman Vasquez, just in view of full disclosure, I, again, have no objections to that. This is your hearing, and that's fine. You can take public comment, but if it is determined ultimately that it will be board-sponsored training, then we will go through the full vetting process, and these groups will all have an opportunity to look at the actual language and the actual implementation that we would be considering doing. So, I just want them to understand, it may happen twice.
Understood. Let me hear from my deputy controller, and then we'll get back, because I know we have people on the line to testify as well.
Thank you, Chairman. Thank you. I'm going to chime in real quick here on behalf of the controller. I want to thank Thomas Parker for your hours of dedication to this training program. I know it was a huge ask, and you churned out some good work product here for review. However, the controller is in agreement with CADA here. She feels comfortable if there's going to be some input from Caltax, from CADA, from all our property tax administrative stakeholders. I think it's important to hear them out as well. And I agree with you also, Chairman, to maybe possibly continue this into September, give some time to review, because you never know the training. There could be more added. There could be some things that are deleted or whatnot. But I think it's actually good governance on our behalf to really hear everyone out and kind of take it from there, because it is a one of a kind type endeavor here. And I think we'll be doing everyone right, all our partners and all our stakeholders right by really vetting this out entirely, especially like you're all mentioning, it's going to be board sponsored on the website. County councils and maybe possibly even 40 million residents are going to have access to this training, right? So we want to make sure that we're putting the best product on the website, and something that we're all can come into consensus and agreement with. So that will be the controller's stance at this point. Thank you.
Thank you. With that, why don't we go back to, we have these folks on the line. Let's hear their input, and then it'll be on our lap to decide what we do with it at this point.
Mr. Yen is on the line. Oh, I don't see Mr. Yen up there right now. Is he available? Yes, he's on the line. He was slated to make a presentation next.
Would you like me to make the presentation or should I withhold?
Well,
Until
listening
later.
to our conversation, I'll leave it up to you. What do you think? Does it make sense at this point?
I think it's an opportunity to just really showcase what LA County is doing, even with your materials that are available on the board. But I guess within this vein of conversation, it may be better to postpone this presentation.
Okay. I'm good with that. Did you have any comments you wanted to make at this point, or are you good?
You know, I think just to share a little bit about what LA County Assessment Appeals Board has done in its role in trying to ensure that we're listening to stakeholders like those who are before you, as well as the assessor's office in LA County, is that in many assessment appeals board, you know, with limited resources we are working together through our conferences with our associations to try to increase the knowledge of our assessment appeals board members. The opportunity I wanted to use today was really just to showcase that, at least in LA County, we have listened to our stakeholders and we've improved some of our training curriculum. And you know, what Mr. Parker has offered to you today is one of those resources that he has continuously offered as part of our council, our county council. And just want to thank him for his continuous service to LA County, as well as to the state of California and the other county council attorneys that he supports with his leadership as well as his insight. So that's all I have. Thank you.
Thank you. And I think we had somebody else on the line, didn't we?
Yes, we do have one other speaker, Honorable Christine Lee, President, California Assessors Association, and Kings County Assessor Recorder Clerk.
Welcome.
Thank you. Good afternoon, Chairman, members of the board, Deputy Controller, and others in attendance. I appreciate you allowing me to speak today. The CAA is similar to CADA in that we did not have the material until rather recently, and so we have not vetted the material. We do think the material is important, and we are supportive and appreciative of, I feel like I'm echoing, I'm sorry.
No, you're okay.
Okay. We do appreciate the efforts of Mr. Parker and the importance of this subject, because especially in the small and mid-sized counties, our county councils are spread rather thin, and they oversee several departments, and they do not necessarily specialize in assessment appeals, and so, or the laws and rules surrounding the appeals. So this sort of document, I think, would be very, very beneficial in helping them to be, you know, more knowledgeable in this area. So we are supportive of the document in a sense, but we have not had the chance to vet it as an organization if you did want our feedback on it. Thank you.
Thank you. Who else? Oh, did you have Vice Chair Schaefer? Oh, okay. Did you have a comment?
I do have a comment.
Okay.
If you guys do not mind.
Sure, go ahead.
Thank you. Good afternoon, Yvette Stowers, Executive Director. Thank you, Mr. Parker, for preparing the documentation. Thank you to Mark, Mr. Priya, and your associates for coming forward for this public meeting. Thank you, Assessor Lee. I hear what you guys are saying. For some reason, perhaps there was a glitch in our system, and when you went to look at it at the August meeting, you did not see it. So you didn't have an opportunity, a good 30 days, to review the document. I also hear what my legal counsel is saying, that even if there is input, we won't be in a position to change it. but Mr. Parker can make a decision to change it. So my suggestion is, why don't we postpone this public hearing to the next scheduled board meeting? That way, everybody will have an opportunity to review the document, and you guys could submit your comments. You can come back to us and submit your comments verbally, or you can submit your comments to board proceedings. And that way, we'll make sure all comments are placed into the record.
That was going to be my motion, but I wanted at least to have all the folks, and I think we have one more waiting, no?
No?
No.
we have
Oh,
no
is that
one
the
else.
last one?
Yes.
Oh, okay. And then I'm hearing my vice chair. Go ahead, Vice Chair, Ms. Liebert.
Thank you. Well, throughout this discussion, I'm looking for the clearest, most stable way to proceed forward. And the way that I'd like to suggest is that we kind of go back to the beginning, and that we ask staff to have a conversation with Mr. Parker to see what his reactions and his intention with his materials that he has written and that he has ownership of, and see how he would like to collaborate with us. And then I'd like to suggest that we start over with a fresh agenda item to ask this board to determine whether we need to augment or otherwise change the training path that we have control of, that we own and we define. And one of those options could be, yes, Mr. Parker says he wants to continue with us and we want to continue with him. And he has given permission for us to adopt his intellectual property. And then we say, okay, then it would come under 162402, and then we're going to schedule a really full hearing with all of the entities that would like to give meaningful comment. So, if that would be like 2 months out from now if we proceed to that step. So that is a good amount of time for everybody to get themselves together to make really meaningful comment. But I think that way we kind of clarify things, and Mr. Parker has put a lot of intention into this, and he's highlighted these issues as far as the county council, as did Assessor Christine Lee, who talked about, with some of the smaller counties, the pressure that is on them to fulfill all these types of functions. So I don't know exactly how to put that into a motion, other than, if I may, Mr. Chair, I'd like to move that we ask staff to meet with Mr. Thomas Parker and gauge his interest, and that regardless of how those conversations turn out, that we bring an item back to the next board meeting, if it's feasible for it to come to that meeting, to talk as a board about whether or not we need to augment our materials and our help for county council training. And then we go to the next step of a hearing where everybody gets to really give substantively considered, so that CADA can go and have their board approve it and those kinds of things.
I guess mine's a procedural question. I don't mind the motion, but I guess I want to ask, since I think, Ms. Nanja, you mentioned that since this was already on the agenda, because it sounds like we want to, I hear my vice chair saying she wants to start fresh. Is that, I guess I'm trying to figure out on a procedural point of view, is this something that we can do, or is it better just to continue what we started?
No, you have the authority as the board to change directions, make different plans, so you can go proceed along Vice Chair Lieber's suggested path, if that's what you choose to do.
So let me hear it again then. I guess so.
So my motion is that we ask staff to confer with Mr. Parker.
Okay.
about how he wants to proceed with his product that he owns. And that an item come forward at the next feasible board meeting, preferably next month, to have the board decide if we need to augment the training that we already provide. And then proceed from there. If we decide yes, then we proceed to the hearing, because that gives everyone 60 days of real clarity that
review.
they can stand on that.
And then we go through.
And then we go through
So-
an actual hearing. I
Yes.
think what you had
Yeah,
mentioned,
okay.
at the end of the day, we'd
Yeah.
probably, even though we did a hearing, we'd probably do another one. This might eliminate that, correct?
Right.
Why don't we do that? So we eliminate, because I don't want to put people through two different hearings if we don't have to.
Well, I mean, it would be,
Here we go.
if we decide that we want to either add this training or augment it, we would go through, we would also present at that board meeting
Right.
our normal process where people can
Weigh in,
weigh
basically,
in,
yeah.
and that way, everyone will have complete foreknowledge of what's going on. And if anybody is interested on commenting whether or not we even need this training, or what have you, or absolutely we need this training, they can weigh in at that board meeting, so.
Okay, so question of clarity through the chair.
Yes,
Vice Chair Lieber
Yes.
made a motion.
yes.
It sounds like it's a two-step process.
Yes.
Question number one is to speak to Mr. Parker. Are you comfortable with us basically using your curriculum? And if we get permission to do so, question number two would be, and I'm assuming that you're going to provide information for us at our next board meeting on whether we want to add this to our curriculum or not. You'll present it, and then we'll make a decision on that. And then at the next board meeting, we would vote to either approve or not approve that curriculum.
And then move on
And we
with the
take,
hearing.
and we take input like we would
Yeah.
anything else.
Yeah, so the first step of my two-step process would be, before the next board meeting, staff talks with Mr. Parker. And then at the next board meeting, we grapple with the issue of whether or not
Right.
we want to add to our training,
Yes.
maybe with Mr. Parker, maybe in a completely different way. And staff would present to us the normal process that we go through.
Right, right.
And then assuming that the board says, yes, we want to move ahead with that, then we would go to a full public hearing, noticed.
Right.
With all of the
Stakeholders,
applicable communities there being able to give a real full hearing testimony.
Okay. I'll second the motion.
We're good.
Can we get comment from Kata and
Yes, I think
any others?
now that we have a motion, let me hear from,
Yeah.
I know you had your hand up and you were
Yeah,
interested in weighing
Mr.
on this.
Chair,
Go ahead.
Mr. Gaines, members of the board, Ms. Lieber, Mr. Emron, Mr. Schaefer, thank you, and thank you to staff. As we stated up front, we believe that it is the appropriate role for the State Board of Equalization to take a leadership role in providing this kind of training, whether it is of county council or assessment appeals board members. This ensures greater uniformity and consistency across the state. It is also better that there is public input and an opportunity to vet it, whether you're going to cite a specific code section or not. Getting this out into the sunshine is a better way of going about this. And so we would support the motion made by Ms. Lieber. We would also suggest that the questions that you raised are important ones. We do believe that this is an appropriate role for the BoE, but we also want to recommend that whether you're going to develop training material yourselves or adopt somebody else's, if you vote to approve it, then you've voted to approve it. And the board owns that then, right? So, and I know you know this, but that was the concern, that there was somebody else's work product, as respected as he is, that had not received appropriate vetting either by property tax agents, a taxpayer organization, or the California Assessors Association, and that you were on the cusp of voting to approve that curriculum without the opportunity for review and public comment. So we commend the board for spending all of this time through all of this this afternoon. We thank you, and we want to, again, lend our support to Ms. Lieber's motion.
Thank you.
Thank you.
With that, let's see, we have anybody on the line
Okay.
that wants to speak to this.
So the people in the audience have spoken, so I have nothing in writing on this comment, so let's go to the moderator. Oh, yes. Is there anyone else who's come in through the Teams would like to make a comment?
They might have us on mute. Because I see them, but I don't hear them.
Okay, well, then it looks like nothing else. Let's go to the moderator.
Okay.
AT&T moderator, is there anyone on the line who would like to make a public comment regarding this item?
Ladies and gentlemen, as a reminder, if you wish to make a comment on this item, you may press 1, then 0. And there's currently no one queuing up at the time.
Thank you, moderator. I have a motion. I'm going to read it, and I hope, Ms. Lieber, it's okay if I do one adjustment. You had asked staff to do it. I'm going to adjust it to say that you're directing the executive director. So I do have a motion by Vice Chair Lieber, seconded by Mr. Gaines, and the motion is, my motion that I ask the executive director to confer with Mr. Parker about how he wants to proceed with this product that he owns, and that an item come forward at the next feasible board meeting, preferably next month, to have the board decide if we need to augment the training that we already provide. And then proceed from there. If we decide yes, then we proceed to the hearing, because that gives everyone 60 days of real clarity that they can stand on that. All righty, I'll take roll. Chair Vasquez.
Aye.
Vice Chair Lieber.
Aye.
Member Gaines.
Aye.
Member Schaefer.
Aye.
Deputy Controller Emron.
Aye.
So that's unanimous of all those present. Thank you, everybody, for your patience and a little bit of the confusion. And like we said, we were treading on new territory here. But I think at the end of the day, it looks like hopefully we'll get a better and a better product, and hopefully enrich what we currently do now.
Thank you, member.
Thank you all.
Thank you.
Thank you for coming out. With that, Ms. Cicchetti, what's our next item?
I believe we should take a quick
you
break
need a
for
quick break?
staff. Yeah, so if
Okay.
we could do a 10 or 15-minute break, that would be great.
Is it 10 minutes sufficient? I'm hearing, I'm seeing nods, okay.
Yes.
So it's 2:18, at 2:28, we'll reconvene here.
Thank you. order in the room if you want.
Welcome back. It's 2:30 and we'll reconvene.
Are we good?
I think we're good, right? Yeah, I'm looking over.
Hold on 1 second,
All
let me
right.
just check.
Ms. Cicchetti, I think you said, what's our next order of business? here?
Okay. I just want to make sure that we're all linked right here. Let me just check in the back.
Oh, is
We're good?
AT&T on?
Okay, yep,
They
we're
are?
connected.
Okay.
I just wanted to make sure. Because we took item 5 out of order right after lunch to accommodate the speakers, we're going to go back to where we were on the agenda.
Which
So we
was-
go back, we're up to item 9.
That's page 29, is that correct?
21 on your thing, 21? Alrighty, item 9, board member matters and initiatives. 2024 board member annual agenda workload plan, potential issues calendar. Proposed 2024 board meeting, potential issues agenda plan, tentatively scheduling key subjects and critical issues for each meeting date on the calendar to serve as a substantive roadmap for minimizing transparency and engagement opportunities for all stakeholders over the next year. This matter will be presented by Mr. Vasquez.
I do have, but you said it's item 9?
Item 9, correct. I did, I said page 21 on your,
Oh, I was looking at 29, okay, hang on.
apologize. That's ours.
Here it is, okay. All this going back and forth, you lose track of.
Yes, I know, it is.
Members, I submitted to you a potential issues calendar for the tentative board schedule of issues for us to consider in 2024. It is important to identify the critical issues and challenges facing us in addition to the items and cases the board is mandated to address. The potential issues calendar lists items known or anticipated at this time, but as other issues emerge, we can update the calendar as needed. The potential issues calendar is intended to clarify the board's expectations and also set the tone and pace for the robust public engagement. Above all, the goal is to establish an annual agenda plan that furthers our efficiency and effectiveness in planning meetings and increases the transparency for all stakeholders. For example, the board meeting agendas on the proposed calendar each include at least 1 or 2 board work group meetings each month, timely budget reports and speakers, time-sensitive input from state legislators on bills, and reports relevant to periodical milestones for the executive director. I encourage your review and input, including any suggestions you may have, so we can bring this back for adoption at our October 24th board meeting. With that, let me just see if people had any comments or suggestions, because I did get a call from one of our board members, and I just assured them that this was not something that was set in stone yet, but I wanted to at least get it out there. And if you all have any other suggestions or ideas or topics to start, at least begin to think about now what we're looking to do for the calendar year 2024. With that, let me just open it up. And I think my vice chair wants to weigh in. Go ahead. Ms.
Very,
Leader.
very sensitive, Mr. Chair. I only had my finger slightly towards my
Toward it.
button. But I think you could feel the
I felt the
movement,
vibe.
the vibes over here. So I'm hoping that we can push this out a bit, especially given our discussion today and the discussion that we're going to have at our October meeting in reference to additional training, and I think that would definitely entail a commitment to a series of hearings, potentially, and an additional workflow. So I didn't see anything on here that I didn't agree with. I do expect perhaps in December or January to be able to bring forward more information about our request for a work group that is around environmental impacts and property taxes. And so I think it's a sort of a moving target at this point to weave in what we've already committed to, and also to decide when we're done on a particular topic or work group and call it good. So if we could get the breathing room until November, I think things will really become much more solid in October at that meeting.
I'm open. I just threw it out there. I wasn't wedded to the October date, and if people are comfortable with that, and I see Member Gaines wants to weigh in as well.
Yeah, that's great on the schedule for that item. And then if we have something in particular that we might want to include,
Sure.
we can communicate that to Executive Director or, okay.
Yeah.
All right, very well.
Yeah, I just wanted us to at least put that in your mind to start thinking about what we're looking at, because I know we've hashed out some real good things, and I really like the synergy that we're developing here. I just want to make sure we stay focused somewhat, right? And I know we had this conversation early on with our previous executive director, and I wanted to put it out there because I know now under the new leadership with our current executive director is to make sure that we're all on the same page. And somewhere down the road, I guess we should, I don't know if we need to do any kind of maybe a follow-up formal retreat, but at least maybe a follow-up, because we had set up way back, I remember, long-term, short-term goals, and some of them were completed, and we kind of closed them out. Some were like long-term that have turned into like short or medium now. And we might want to revisit that at some point. And like what you're mentioning, Vice Chair, we never really even got into the whole environmental issue because we were so focused on just property tax issues, and the affordable housing kind of hit us. And then on top of that, we had Prop 19 that just kind of took us for a whole nother loop. So I just want to see if we can maybe start thinking about it. And if it takes us until November, I'm comfortable with that. But as we're waiting, let's think about how strategically we can kind of focus a little bit and make sure that we're hitting not only our long-term, but our short-term goals. And I see my executive director wants to weigh in. Go
That's
ahead.
very fair, very reasonable.
You getting a buzz?
Yeah.
I was hearing it too.
Anyway, sir, me back up. Appreciate what Vice Chair Lieber said about let's look at this in November. I understand what you said, that there may have been some conversation with the previous executive director regarding the calendar for the year. And, I thought she had implemented everything that she talked about, but she may have taken a different turn. And I'll just give for an example. On this proposed calendar for 2024, you have I'm assigned to it, but it's a 2024 legislation research update outlook for 2024, selection of legislation priorities and goals, and then similar for the property tax department outlook for 2024, priorities, hot topics, benchmarks, and goals. I would like to take a look at that a little further and really have a conversation with you, sir, on what you're thinking of, because as you know, we report out monthly on what has been accomplished. And then on a quarterly basis, we do budget reports, we do the legal report, and we do the communication report. We do it on a calendar quarterly end. Well, although the quarter, let's say, quarter end in September, we're going to do a report in October because it takes time to gather data. So, but when I look at this calendar, it's asking for quarterly reports on budget items as soon as the quarter ends, and that's just not feasible.
Right.
So again, I would like to take a look at this and let me kind of work with it and the priorities, the potential topics that you have, and whatever other potential topics that we have, and then factor in all of the other work that we do, and or and wanting to be respectful of everybody's time and resources, because having 2 work groups per meeting, I'm sure your staff is exhausted.
They are. Yeah.
So that's that. As far as the short-term, mid-term goals, I believe you're referencing the board member strategic plan.
Yes.
For 2020 through 2023. I believe that most of those goals have been accomplished.
I think you might be right.
And I strongly urge that you guys do have another retreat to talk about your goals for 24 through 2026. And that's another example. It's discussion about your goals on this proposed calendar, but it's not until March or April.
Right.
I would think that you might want to get that a little sooner. And knowing what your goals are may really shape the topics here. But
Member Schaefer, I think, wants, go ahead.
I was going over the 2024 calendar, and I see you have a schedule on the 2024 calendar for 2-day meetings every month. I've heard a rumor that it might run into a 3rd day sometimes. My experience is that most of the 2-day meetings have become 1 day because we've been able to get our stuff done. I come up this morning on the 6:30 plane and I get in at 8 o'clock. We could have had the meeting today at 9 o'clock. In fact, I was here at 10 minutes to 9, watching everybody set up. I guess what I'm saying is when we have an occasion where we can maybe start at 9 o'clock and get it all done in 1 day, that would save the state money of housing us at hotels and stuff, and it would make us maybe a little more efficient. I'm jealous that Member Gaines, lives here, and I live 500-600 miles away. I'd just like to speak up for if we are going to have half of our meetings do 1 day like they have been the last year, that we try to say so on the calendar so the public will know that if they want to see us, they're going to have to come on Tuesday and not Wednesday. And if we can sort of have a handle on how long people are going to speak and that they're not going to speak twice and they're not going to duplicate themselves, I call that good agenda management. I would just like to ask that we have a goal of trying to have as many 1-day meetings, maybe a little longer, maybe a little more efficient, for the benefit of those of us who have to travel, spend 3 or 4 hours in a plane just to get to work and back. Thank you.
you're welcome, sir. That's actually going to be coming up under item number 11.
Coming up next, I saw
Yes,
that. I was
yeah.
waiting, yeah.
Yeah.
We're going to talk about it on item 11.
Oh, thank you. You're ahead of me.
Yes. You're ahead of us, actually.
So that's
Go
all I
ahead.
wanted to say. I think that November date, for the come back with some more issues is perfect. Give me an opportunity, once I get your issues, to really map things out on how many issues, work groups can we do in one board meeting? And hearing Mr. Schaefer's concerns as well. And then me understanding some of the items that's on here. And that's Chairman, I would love to have a conversation with you on that and saying that, is it the same what we've been doing? Are you looking for something else? Like another thing, come January, I will be doing a report on the agency accomplished for the 2023 year. So there's a lot going on. There's a lot of moving parts, and to recognize that we have a matrix that we work with. I say we, board proceedings. identifying things that's going to be discussed, including various reports. So, thank you.
Deputy Controller, go ahead.
Thank you, Chairman. I'll be very, very brief. I just want to thank you and your office for all the hard work in putting this list together. 2024 is on the horizon. It's really, really exciting to think about us planning the year ahead and continue to build on the progress of 2023. I think it's been an incredible year, and I know next year is going to be even better. The controller doesn't have a problem making this, putting this off until November too. I know it's a very fluid list and things can be added as well. So I'm looking forward to all the board members, the executive director, everyone's input in making 2024 the best year ever. Thank you.
Thank you. With that, I think we'll go on. We don't need to have public comment on this one, do we?
No.
No.
No
Let's
vote.
go ahead and move on to our next item.
Our next
Mr.
item.
Chair.
Section 10.
That's you? Yeah. The next item on the agenda is item 10, Executive Director's Report, report on the status of pending and upcoming organizational issues. This matter is being presented by Ms. Stowers.
Welcome.
Thank you. Yvette Stowers, Executive Director. Good afternoon, Chairman Vasquez and honorable members. I am Yvette Stowers, Executive Director. For today's report, I will start by providing an update on recent and upcoming events. I will then bring the team up to provide an overview of the recently enacted changes to the Bagley-King Open Meeting Act. Up first, members, on September 21st, the BoE participated in the California Society of Enrolled Agents Annual State Tax Agency Liaison Meeting. Mr. David Young, Deputy Director of the Property Tax Department, discussed the frequent disasters occurring in California and how these disasters impact property tax and the BoE. Mr. Young was followed by Ms. Lisa Thompson, our taxpayer rights advocate, who shared some valuable information available to assist taxpayers. And finally, I gave a brief presentation on pending legislation affecting the BoE. This was our second appearance at this annual event, and I believe it provides an excellent opportunity and forum for outreach to various stakeholders. I would like to thank the California Society of Enrolled Agents for inviting the BoE to participate, and we look forward to the event next year. Next, members, I would like to highlight a few important dates on the horizon. Members, as you know, the annual meeting with the county assessors is scheduled for tomorrow, September 27th. And this meeting is a requirement under Government Code 15607. It is an excellent opportunity and forum for a dialogue amongst the members of the Board of Equalization and the 50th county assessors. Conversation relating to the administration of property assessment and taxation law. The first half of the meeting agenda will include public presentation and discussion, followed by the second half of the meeting for the county assessors to individually meet with their representative in the equalization district. Then, members, on October 3rd, Friday through November 3rd, the annual California Assessors Conference will take place in Palm Springs. And finally, on November 1st through the 3rd, the California Lawyers Association will hold the 2023 annual meeting of the Tax Bar and Tax Policy Conference. I will continue to keep your office update on these various details. And on a side note, I do owe you guys an email on the CEA conference. I'm working on it. I had a little hiccup last week, so, but you will get it soon. Next, for my other part of the report, I would like to invite the team up to talk about the recent changes to the Bagley-King Act. I would like to invite Mr. Henry Nandro, Ms. Julia Hibbowitz, and Mr. Ted Angela.
Good afternoon, Chair Vasquez and honorable members. My name is Julia Himovitz. I'm with the BoE Legal Department. Senate Bill 143 was approved by the governor and filed with the Secretary of State on September 13th, 2023. This bill extends many of the provisions of the previous executive orders that suspended some of the provisions of the Bagley-Keene Open Meeting Act and allowed state bodies to conduct public meetings via teleconferencing. The Bagley-Keene Open Meeting Act requires, with specified exceptions, that all meetings of a state body be open and public, and all persons be permitted to attend any meeting of a state body. Bagley-Keene authorizes meetings through teleconference subject to specified requirements, including, among others, that the state body post agendas at all teleconference locations, that each teleconference location be identified in the notice and agenda of the meeting or proceeding, that each teleconference location be accessible to the public, that the agenda provide an opportunity for members of the public to address the state body directly at each teleconference location, and that at least one member of the state body be physically present at the location specified in the notice of the meeting. The Board of Equalization, as you know, is a state body, and therefore it's subject to Bagley-Keene. During the COVID-19 public health emergency, former Government Code Section 11133 suspended specified Bagley-Keene requirements for state body meetings held through teleconferencing, including identifying each teleconference location in the notice and agenda of the meeting or proceeding, and making each teleconference location accessible to the public. This code section was effective June 30th, 2022, and was repealed as of July 1, 2023. So SB 143 is reinstating Government Code Section 11133 until December 31st, 2023. Specifically, this provision suspends the following rules for any state body, including the BoE, holding a public meeting through teleconferencing. Each teleconference location of a participating member must be identified in the notice and agenda of the public meeting or proceeding. Each teleconference location must be accessible to the public. Members of the public may address the state body at each teleconference location, post agendas at all teleconference locations. At least one member of the state body must be physically present at the location specified in the notice of the meeting. And as I said before, this provision is effective and operative as of September 13th. And it remains in effect only until December 31st, 2023, and as of that date would be repealed.
Thank you
That's it.
Thank you very much. We'll now go to Mr. Ted Angelo.
Chairman Vasquez, honorable members, I'm Ted Angelo, Chief of the Legislative Research and Statistics Division. I'm not an attorney, but I've played one on TV. Sorry, old joke. So mine will not be as technical of an update because this is a difficult issue, and I just want to start with a caveat that Mr. Nanjo will be putting together and the legal division that you've heard from today, and the whole team will be putting together guidance for the bill I'm talking about now, which was just recently signed by the governor day before yesterday, I believe. So the budget trailer bill just continued the Bagley-Keene remote participation provisions that were put in place during COVID until the end of the year. So SB 544 puts in place a different set of remote participation rules starting January 1st, 2024, now that the bill is signed. And they are not quite as permissive as those that have been in place over the last few years post-COVID. In essence, all pre-COVID Bagley-Keene in-person and open meeting rules are back to normal, except for a few new limited changes. SB 544 allows a state body to hold open or closed meetings by teleconference, provided the meeting complies with specified requirements. And there's all of these definitions for teleconference location, remote location, and participate remotely are all defined in the bill. They're similar to what we have in place now. For the state body to hold for these specified new requirements, a majority of the members must be physically present at the same teleconference location. So, and this is, again, starting January 1. For example, this board meeting room that we're in today would be a teleconference location. So the majority of the board members need to be present here. Additional members of the state body in excess of the majority may attend and participate in the meeting room from a remote location. A remote location is not required to be accessible to the public. So somebody teleconferencing in, or video conferencing in will not have to have that remote location identified. They won't have to have agendas there, some of the provisions that were in place before. So it protects their kind of privacy of a residence and whatnot. Disabled members, in addition, from some of the provisions that were being talked about during the committee process before this bill went to the floor, came from disability rights advocates and ADA concerns. So disabled members will be able to participate remotely and will actually count towards the majority being present in the location where the majority resides. If a member of the state body attends the meeting by teleconference from a remote location, the member shall disclose whether an individual 18 years of age or older is also present in the room. That's a new requirement. In some limited circumstances, if a required remote connection has failed and cannot be restored, the legislation contemplates the meeting having to end or adjourn. So there are a number of legal compliance issues that need to be reviewed and closely analyzed. So Mr. Nanjo and the legal team will have further details for you in the weeks ahead of the January 1 effective date. And if you have any further questions, we can go over them.
It looks like we do have one question for Mr. Schaefer, Member Schaefer.
Thank you for your information here. From what I'm hearing, I could attend remotely from San Diego so long as a majority of the board is present at the other end of the line. I'm also disabled. Does that give me any special considerations?
Yes. So you would, that remote participation in that, if you are truly have a disability status, you would count towards the majority being present here with your remote participation.
And
That might address your early flight concern, but I'm just kidding on that.
yeah, all right, thank you.
Deputy Controller, I believe you had a question.
Yes, just a really quick question. I want to thank you both for your presentation too. You, just for clarification purposes, the sunset date is the end of this year?
Yeah.
For which?
For the first?
Yes.
Do you,
Go ahead.
Go ahead, please.
Yes, it's only in effect until December 31st, 2023.
2023. Do you, and then Mr. Angelo, is there, have you heard about any appetite to kind of extend this into 2024, or is it just for the next couple months?
Oh, I'm sorry. So the bill also, and I didn't highlight this, but the new law that starts January 1 has a 2-year sunset date.
Okay.
So it'll have to be addressed during that time frame if they want to extend it. Otherwise, it'll end at the end of 2026.
Thank you.
The new
Thank you so much.
provisions, but thank
Chairman
you.
Vasquez, if I can just kind of give you a Cliff Notes version. So Deputy Controller Imran, through the chair, what has happened is the budget trailer bill that Ms. Himovitz was talking about basically restores the remote hearing process that we had up until it expired on July 1st. So that's operative until the end of the year. Then what the governors recently signed was SB 544, and that kind of changes things up a little bit. That's good for 2 years through 24, 25, and expires in January of 26. That allows remote participation by members, but adds a different bunch of rules, and there's some language that isn't entirely clear, which is why legal will have to analyze that. As you know, the legal department, I've sent memos kind of giving the board members an up-to-date status every time Bagley-Keene changes. We'll be doing that for SB 544 and let you know what that looks like January 1st going forward. But for now, until the end of this year, we're kind of back to the way it was prior to July 1st, the relaxed remote teleconference rules.
Okay, I appreciate the clarification. Thank you.
Absolutely. Thank you.
And along those lines, I think you might have mentioned in your remarks earlier, is it, like, for example, if a member mentioned that if they wanted to be remote, don't they have to post where they're at? And by law, I guess, public is welcome to attend wherever they're at. Like if they're whether they're at their home or at a hotel?
No, that's.
'Cause I know under the Brown Act, you have to do that. I don't
Right.
know if Bagley
That-
was the same.
That's been changed for right now, you don't have to do that because we're back to the relaxed teleconference rules.
Oh.
Under 544, you also don't have to do that, but there are some additional requirements that the public has to have, I believe the
Access,
term
no?
equal access.
Yeah.
That doesn't mean at the location, that means that they need to have similar access, calling in or participating. That's one of the areas we have to analyze. The other rule, as Mr. Angelo mentioned, that's a little bit different, is there is an affirmative obligation by the member who's teleconferencing remotely to disclose whether or not there's anybody over 18 in the room that they're in. So that's kind of a new rule. So
What is the
there are.
basis, Henry, for that over 18?
What's that?
What's the basis for that over 18?
It's so that the public knows that there might be other adults who may be having conversations in the background with the person
member.
participating remotely, right?
Oh, it's a privacy issue.
Yeah, it's in the code now, so that remains to be challenged, sir.
If the other person was only 17, they wouldn't care.
17 and a half, right? So anyway, again, we will be providing an update to our memo and letting you all know what the rules of engagement are going forward past January.
After January, okay.
Yeah.
Vice Chair Lieber.
Just a really quick comment. SB 444, that's Mr. Laird's bill?
544.
544. And just, you know, I think that every time that we have an inclusion of disability accommodation in a bill, it just helps us have a much more cohesive net of rights in California. So I'm very much appreciative of that feature of the legislation. So I'm excited to get more information about the ins and outs of how we interpret that.
Yeah.
Absolutely.
Thank you.
It was definitely part of the discussions in the committee process for full access for disability rights while still having all the open provisions of the Bagley-Keene requirements in place and finding a happy medium to have that balance.
Thank you. You know what, just on your, I think it was more on your comments.
Yeah, I was going to say, do you have any questions for me?
I do have a couple. I got lost in all this legal jargon we were talking about, but you mentioned I guess there's a couple conferences coming up in Palm Springs. Are they like in close proximity?
They're about,
So the two conferences, actually, I may be attending both, which is why I researched this.
Okay.
The CAA conference is in Palm Springs. It's kind of on the north side of Palm Springs. The California Tax Policy, the Lawyers Association conference is in Rancho Mirage. By my last MapQuest, it's about 30-minute drive from one location to the other. So they're not too far away, but they're not right across the street either. So
And you're speaking at the tax policy conference. no?
yes.
And what are they asking you to speak on at the
So at the tax policy conference, the last item of the last day is always the chief counsel's roundtable. And it's the chief counsel of FTB, CDTFA, Office of Tax Appeals, and BoE. And we basically just give the attendees an update of what's going on in our department and give them a chance to ask questions to the chief counsels. It's tends to be attended very well, but unfortunately, because they're trying to keep people around, it is literally the last item on the last day.
Could I ask when it would be the best time for any of us who might attend?
I believe for both, when you get the information from, Executive Director Stowers on the CAA conference, you should have a link to the agenda. And if you go to the California Lawyers Association website, there's also a link to the agenda there, so you can take a look at what might interest you. I note that our controller is featured for the tax policy conference on the first day, so you may want to attend that, but yeah.
Then what is she going to be speaking on? I noticed she's on the first, right? Do we happen to know?
Yeah, she'll be speaking about everything. But I really want to appreciate you too, Mr. Nanjo. I got to attend last year, the Chief Council Roundtable. You represent this organization in the best light. Thank you.
Thank you very much.
Henry, what is the name of that website again?
It's the California Lawyers Association website.
Thank you.
Mr. Schaefer, I will send it to you.
You're going to send us, I
Yeah,
imagine.
I'm gonna
right?
send it to you. I'm working on it in my head right now. I just got behind
Hey,
schedule.
what are the dates on that? I'm assuming, I didn't see.
The CAA conference, I believe, goes from the 31st through the 2nd, 31st of October, Halloween.
Halloween, what's that?
Yeah, to the 2nd of November, and the California Lawyers Association Tax Policy Conference goes November 1st through the 3rd.
To the 3rd.
So there's some overlap there.
Well, that first to the third sounds a little bit better than the 31st.
Yeah.
Thanks.
Okay, thank you.
Seeing no other hands or comments, I think we're
Any
good.
more questions?
I had a question. I noticed that there's little green boxes on a calendar here. I can't figure out what they're for.
Which calendar? Is that item number 11?
That's the next
Okay,
item.
perfect.
We're getting ready. I think
Lead
it's going to come up next.
Are you
Oh,
ready?
it's going to come out next.
Yes.
Next, yes.
Well, let Ms. Cicchetti go ahead.
Okay,
Thank
I'm
you.
sorry.
You're right there. Here we
Right
go.
there, yeah. The next item on the agenda is item 11.
There we go.
Board meeting dates and property tax calendars for 2024. Staff recommendations for the 2024 board meeting dates and property tax calendars for the board's adoption. Significant dates considered in setting board meeting dates are included for additional context. This matter will be presented by Ms. Stowers.
Good afternoon. Next, I am presenting for your consideration the proposed board meeting dates and property tax calendar for 2024. The proposed meeting date calendar is based upon statutory timeframes and deadlines. It also includes the 2024 property tax calendar and other significant dates for your reference and planning. The items presented for the board discussion and consideration. The board's adoption of the proposed board meeting dates and property tax calendar for 2024 before you today will allow staff to prepare the calendar of the regular board meeting dates. If at a later date, the board would like to schedule additional meetings, the 2024 workload plan can be updated accordingly. Members, I now ask for your adoption of the proposed board meeting dates and property tax calendar for 2024. Any questions, like the green boxes?
Yes.
The calendar that you have before you is, in February, the green box represents suggested alternate meeting dates. So we have, we're currently suggesting meeting January 23rd and January 24th, February 27th and February 28th, with the alternate meeting date of February 20th to February 21st. For March, the suggested date is March 26th to March 27th, and the alternate date is March 19th to March 20th. We are providing alternate dates because one or more members have asked for a change in dates.
And I think the March 19th and 20 makes sense because I believe the 26, 27 is the break.
Well, yes,
It's
that's,
spring break
that
for a
was,
lot of
it
the
was
legislators,
spring
so they
break
won't
for
be around.
some, it's spring break for the legislators.
But legislators are out,
Yes, so,
which is probably more important than,
that's why that request was made.
that makes sense. yeah.
It's fine by me, because I don't want to have to work on my birthday on the 26th anyway.
Oh,
I have questions.
yes, go ahead, Member Schaefer.
I sort of got the feeling that we meet the last week of the month, not always, but generally. And I think we met the last week of the month this year, except for February, April, October, November, and December. Unless there's a good reason, maybe we should traditionally meet the last week of a month, so both the public and ourselves know that that's coming up, and we'll try to clear out the last week of the month for BoE stuff. That's just a comment. I don't like it saying 2 days every month. If you and I both know we're going to have one-day meetings whenever possible. I know that I came up here this year always expecting 2 days, and last year expecting 2 days, and my chief of staff would say, we're going to be able to get out here today at 5 or 6 or 7 o'clock, and would cancel a hotel for the second night. I think it's important that we put in 1 day if we have good faith reason to think that it might be a day, and we can sort of focus on making it 1 day, you know, by cutting our speakers down to 3 minutes apiece, or however that's done. I think the workplace things that we have can be done in a meeting like in the one in Santa Monica without involving the entire BOE staff and the entire BOE membership. I think some of these workplace members can be done, as Ted and I have talked about, having such a meeting in San Diego, just the two of us. I think that's legal. I think it's good for the public to give them a chance to talk to us, and it's something we can brag about that we've done for the public good, whether there's 5 of us there or 2 or 3 of us there. What I'm trying to do is get some of the unnecessary, non-statutorily required matters away from our former calendar, so that our formal calendar can be eyed as maybe 1 day instead of 2 days, and certainly not 3 days. Thank you.
Duly noted. I would say that we may have some meetings towards the end of the month, but when we're planning out the calendar, we have to consider things like holidays.
Yes.
So we don't like to, it's not really feasible to have a board meeting on a Tuesday following a Monday holiday. So we always move on. And then we're also concerned about if we do everything at the end of the month, if we have a short month or a lot of holidays within that month, you're gonna find us just we're already turning it around every 30 days. But if we get them too close, then we will have less than 15 days to prepare for the next
Post.
meeting.
Why can't we not have a meeting on a Tuesday following a Monday holiday?
For staffing reasons, we need to make sure that everything is working, the equipment is working. So we come in here that Monday and do a check. And if it's a holiday, we're not available to work.
I was thinking that some people don't celebrate the Monday holidays, but the state does. Is that
If it's a paid holiday, we're not working, yeah.
Yeah, thank you.
You're welcome. I think you asked about 2 days, 1 day meetings. We normally schedule meetings for 2 days, and as we develop the calendar and confirm our speakers, we clear with the chair's office on whether or not we can cancel that second day. And once we get confirmation, and we look to get confirmation as early as possible, once we get confirmation, we do share it with the board and their staff.
Sure. Well, I just want to say that a 2-day meeting is much easier for 100% of our staff than it is for Tony and myself, because we have to come from halfway around the world.
And as far as the start time of the meeting, that is something that the board can consider. But at least for if we have a second day meeting, and you're already here, maybe start at 9 o'clock is feasible. But then I don't want to speak for you guys. I live here in the area, but some members don't live in the area and they're driving.
They just changed the airplane. I'm used to getting on the airplane at 8 o'clock and getting here at 9:15, and I get here on time for the meeting, but Southwest changed it. Instead of an 8 o'clock flight, I have a 6:30 flight. So I walk into Sacramento at 8 o'clock now instead of 9:45, and so I'm quite open to a 9 o'clock meeting, and I haven't been that way until now.
Okay, that's good to know. That's something that this
And
board
I
can.
think when I was first elected, it was at 9 o'clock, and I argued for 10 o'clock.
Well, you know, the problem we have is, like, for example, this week, the members are off. So when the legislators are down, Southwest, I know, changes the schedule. Because like I know when I was booking flights, we try to book ours way in advance to save money. A lot of times there's not much flexibility because when they're down, there's not the demand, so they cancel a lot of the flights. And that's why you were flying from, at one point, you were able to get 9 o'clock flights. But now since there's not a demand, they usually do them earlier or they'll cancel them and you get bumped to a later time. So there's no guarantee, that's the problem you have.
Well, you have authority to determine what time the meeting's gonna start, and I'd ask you just consider what
We'll look at
Southwest
it.
can do, okay?
Thank you.
That presents my presentation on the board meeting dates, and I'm asking for the board's adoption.
I'll move staff adoption unless there's other comments or questions.
Just really want to quickly thank you, Chairman. I really want to thank you for getting this ahead of time, and especially looking at the March dates right here, 19th and 20. The controller is the chair of the Franchise Tax Board, and we do meet one time in March too. And then the BoE chair also sits on that board, so I'm gonna work with the Franchise Tax Board and make sure that we can get some dates around the 19th and the 22nd. Thank you.
You're welcome. That's what I did in the past too. That's one reason why we try to get our calendar
Out.
And then the controller and the deputy controller could pick the FTP calendar.
I really appreciate it. Thank you.
So you need a motion to approve the change.
Yeah,
We're talking about changing February 20 to 21 and the March 19 to 20, right?
And then all the other dates is highlighted in yellow.
Yes. I will move the staff, or your recommendation. I'm good with that.
Second.
And it's been seconded by my vice chair. Seeing no other hands or comments?
I have no one in the audience, and I have not received any public written comments on this matter. Let's go to the AT&T moderator. AT&T moderator, is there anyone on the line who'd like to make a public comment regarding this item?
If you would like to make a public comment, please press 1, then 0 at this time.
Ms. Taylor, I'd just like to give you my opinion that the public does not have a right to a seat at the table when all we're discussing is where we meet or what time we meet.
And we have no comment.
Thank you, moderator. All right, I have a motion on the table to adopt the calendar with the two adjustments, the adjustment to change the February date to February 21st, 22nd, and to change the March date to March 19th, 20th, leaving all the remainder of the dates as presented. Chair Vasquez?
Aye.
Vice Chair Lieber?
Aye.
Member Gaines?
Aye.
Member Schaefer?
I vote no, and I state that I don't like two-day meetings unless they're required because we're meeting with the assessors. I would go for 2 days then.
All right. And Deputy Controller Amron?
Aye.
So we have a majority. With that, motion carries. With that, Ms. Cicchetti, what's our next item?
The next item on the agenda is item 12. You don't want me to do the property tax things?
Operational priorities.
All right, next item on the agenda is item 12, operational priorities. Report on the status of operational priorities. This matter is being presented by the Chief Deputy Director, Ms. Renati.
Good
Welcome.
afternoon, Chairman Vasquez, Vice Chair Lieber, and honorable members. My name is Lisa Renati, and I'm the Chief Deputy Director of the Board of Equalization. Today, I'll report on some of the agency's operational priorities and projects. The first item is our recruitment. Since our last meeting, we have successfully filled 5 positions. 2 of the positions are professionals new to the BoE, and 3 are promotions in our property tax department. In the month of October, we are scheduled to attend 6 separate in-person or virtual recruitment and career fair events. The events are sponsored by CalHR, Sac State, Cal State Monterey, American River College, UC Davis, and UC Santa Cruz. Additionally, in the near future, a member of our recruitment team will participate in an informational career event at a local high school. They're going to discuss opportunities in public service at the BoE and the property tax appraisal field. Through consistent and proactive recruitment activities, the agency has reduced our vacancy rate to about 14%, which reflects our dedication to building our robust team. And to put this into perspective, right now our property tax department has 8 vacant appraiser positions that need to be filled. 2 of these vacancies are executive positions, one to lead our County Assessed Properties Division and the other for our newly reestablished Assessment Practices Survey Division, which leaves only 6 vacant auditor or auditor appraiser positions. So our managers and supervisors are doing a great job making sure we have the workforce capacity we need. We'll continue to try to fill these vacancies and keep interest in our positions going, so that way we have that pipeline in the future that we'll need as people retire or get promoted. The next item is our budget. As you're aware, our funding is provided by the general fund for operation of our tax programs. About 86% of our budget is used for personnel services, which is our staff, payroll, and benefits. The remaining 14% is for our office expenses and equipment. For fiscal year 22-23, our expenditure reports have been finalized. Copies have been sent to your office. As an agency as a whole, for combined, we spend about 86% for our payroll expenses and benefits. So we're moving right in the right direction. When those numbers get high, it means we're filling all our vacancies, because as you know, most of our budget is for people, not for paying for expenses. So we're doing very well. For fiscal year 23-24, your working appropriations have been sent to your offices. As an agency, we have about the same number of positions, 193.6, and we're at $33.9 million. So we're doing well on our budget from last year. We look forward to this year, making sure we fill those vacancies to keep our all the money given to us by the people to do the job of running our tax programs well. That concludes my report. If you have any questions, I'm available to answer them.
I have one quick one. I noticed you're in the process of filling, I guess, the 2 CEA positions
Yeah, the
with the
career
chiefs
executive
for the
assignments, yeah.
property tax. I was just kind of curious, what's the process, I guess, to outreach and recruit and get the right qualified candidates for those?
It's a good question. It's just similar for all of our positions, as we do post through CalHR and their CalCareers account. We also we go out through the tax community and send out notices through CDTFA and BoE and different agencies saying we have vacancies. We put them on LinkedIn and get the word out. Once to apply for a position, it's through the CalCareers account at CalHR. It's a competitive merit hiring process. So the first is an examination, and once they get through the examination, have a passing score, then they get selected for interviews. And then there's an interview panel. It's also a merit hiring process, and then the successful candidate is hired. Once we, it's a little even more than that. It goes through an approval process, through all the different groups to make sure that our hiring is fair and meets all the qualifications that need to be done, so that we make sure we have a fair process. So it's posted right now on CalCareers. Anyone listening that's interested, apply or tell a friend. Always looking for candidates.
Thank you. My deputy controller has a question for you.
Thank you, Mr. Renati, for your presentation and for all your hard work. I think you're steering the ship in the right direction. I just had 2 real quick points. I want to thank you for the active recruiting, and I see that UC Santa Cruz and CSU Monterey is on that list, and you getting out not only in Sacramento region, but also on the Central Coast. And then also, too, this my second and last point, the high school presentation that's getting these young people excited about taxes. So I hope that's worthwhile. I hope I can also see that on social media or something as well, so I can repost that on behalf of the controller's office. And then, I know the budget's tight, but if there's some memorabilia, some BoE stickers you can pass out, so you see some young people in some BoE T-shirts, that would be actually really, really nice too.
Gotta
Thank
be
you.
very careful on what we spend our money on. So, thanks.
Member Gaines, I believe, has a question for you.
No, just the comment, thank you.
Oh.
I thought it was very comprehensive overview of what's going on and very encouraging. Yeah, so thanks.
Thank you.
Great job.
Thank you.
Ms. Cicchetti.
The next item is item 14, Property Tax Deputy Director's Report. Report on the status of pending and upcoming projects, activities, and department issues, including letters to assessors, appraisal training and certification, and state-assessed property. These items are being presented by Mr. Young and his team.
Ms. Cicchetti, did we skip 13?
We did not. Number 13 was, we did. No,
Because I haven't heard Ms. Thomas.
apologize. Well, we'll do these first and then we'll go to Ms.
I said, wait a minute, she's changing our agenda. That's,
Do
I-
these.
I didn't know you had the power to do that.
I do, though. I apologize.
Good afternoon, Chair Vasquez, honorable members of the board. Once again, David Young, Deputy Director of the Property Tax Department. For you today, as already mentioned, we have 3 reports. The first 2 will be for the CAPD, or County Assessed Properties Division, will be given by Ms. Glenna Schultz. And then the last one will be given by Mr. Jack McCool of SAPD, the State Assessed Properties Division. So if you're okay and you're ready, I will have Ms. Schultz go ahead and start.
Yes, welcome.
Good afternoon, Chair Vasquez and honorable board members. I'm Glenna Schultz, Principal Property Appraiser in the County Assessed Properties Division. Today, I will provide you with a brief report on letters to assessors. Attached to this month's agenda is a memo on letters to assessors, which provides a list of the LTAs that have been issued since our last board meeting. In addition, the memo provides a link to the BOE's website where a list of all LTAs can be found that have been issued to date. As of the date of the attached memo, BOE staff has issued a total of 32 LTAs for calendar year 2023. Since our last board meeting, 3 of those LTAs have been issued and are summarized as follows. An LTA that announces the annual Urban Agriculture Incentive Zones Act per acre value of California irrigated cropland for the 2024 lien date, an LTA to issue a summary of 2022 property tax litigation, and an LTA to issue the Santa Clara County Assessment Practices Survey. This concludes my report on letters to assessors. I'm available to answer any questions you may have.
I have just a quick one on the one you just mentioned. This is the Urban Agricultural Incentive Zone, is that the one?
Okay?
Which is, I think, kind of creative how you're doing this. And it gives folks the opportunity that are sitting, I guess, on vacant land to kind of repurpose it, is what
Yes.
I'm reading. Can you give us an example of how taxpayers can learn about this? I imagine they can go on the website. Is it pretty easy, friend, or is it just a link they can click on?
Yeah, if I may, is it in front? Yeah. So this is, you're exactly right. It is an opportunity for folks with either vacant land or land they can use in the urban area in order to do basically urban farming. It could be anything from
Like community gardens or something?
Yeah, community gardens. Actually, some of it is actually productive gardening. They actually have urban farms that grow like strawberries in a major city and whatnot. So there's a couple of things there's a couple of requirements in there. There's a minimum size that you have to have and a maximum size. But once you go, you actually have to enter into a contract with the city or the county of where you're at. There's restrictions placed on the land. And with that, you get this great benefit of having it basically, you know what your assessment will be every year. It's based on the average dollar per acre of irrigated land. For this upcoming year, it's $18,600. So you just take how many acres you have, multiply by that, you know what your assessment will be.
Wow.
So you do have to, but the caveat to that is you actually do have to engage with the local government and actually enter into a contract. So it's restricted for a little bit.
And is that contract, is that like a yearly contract?
It's it depends on how long you have to agree to a term of restriction with
the city or
the city or county.
jurisdiction.
Usually it's a couple of years, and I believe the minimum acreage is about 1/10 of an acre, but the most is about 3 acres. So there's a size restriction. There's what you can do with it, but the upside of that is you know what your taxes will be, and if you're in an urban area, $18,600 per acre is typically a pretty good assessment. It's a pretty decent assessment value for you.
Was there a rationale or reason why they came up with that? You said you can't go over 3 acres, right?
Yeah, there's limitations to it. So they don't want you just to have a small plot in your
Right.
front yard, and they don't want you to have basically 40 acres and try to squeeze it in there. So
Okay.
it's really, really geared towards a true urban farm. So,
Like a real community garden,
yeah,
I guess,
yeah.
That's good.
Okay.
Other questions, comments? I think we're good.
Okay.
Thanks.
I will now provide a brief report on the BOE's appraisal training and certification program. For the 2023-24 fiscal year, we have scheduled 34 classes and 3 workshops. Since the last board meeting, 4 classes have been taught. We also continue to offer our existing online basic training courses available through American River College and California State University, Sacramento, as well as our online courses and self-study training sessions available on the BOE's website. This concludes my report on training and certification. I'm available to answer any questions.
Seeing no hands, I think we're good.
Thank you.
Thanks.
Mr. McCool?
Thank you. Good afternoon, Chair Vasquez and honorable members. My name is Jack McCool, Chief of the State Assessed Properties Division. Today, I will provide information on the status of ongoing work in our division. SAPD staff continue to make good progress on our 2023 property tax audits. Staff sent initial audit letters to assessees this past June, and most of those audits have now been completed. Staff are finishing writing the audit reports, and some reports are now in the review stage. Each audit report will go through several levels of review before being sent to the assessees. Any audits that result in a change in value recommendation will go before the board. Some audits may come before the board before the end of this year, but most likely they will begin to come on the agenda in early of 2024. SAPD staff also continue to make progress on our petition workload. Staff are preparing for appeals conferences scheduled in October. We also continue to work with petitioners on trying to find resolutions to outstanding issues. We will continue to work on the appeals throughout the remainder of this year. That concludes my monthly update for the State Assessed Properties Division, and I'm available if you have any questions. Thank you.
I don't see anything, but I had one quick question. Sure. I recall you mentioned that the unit is getting back to normal workloads. I'm thinking, with the whole pandemic now kind of behind us somewhat, have you observed anything out of the ordinary moving forward since then? Because I know the workload, a lot of people are still trying to work remotely, and I was
Sure.
wondering what kind of impact that might have.
Sure. So for our particular workload, the workload remained the same throughout the pandemic. The one area specifically for the State Assessed Properties Division that was impacted the most by the pandemic was our inability to travel for a period of time. That severely limited, in particular, our ability to conduct in-person audits. So for a few years, we did have a voluntary change basically in our workload. So we made a decision to pivot from having in-person audits to having several significantly fewer targeted audits that could be done, basically what we call a desk audit. So it would not involve any travel, but it would involve the electronic exchange of information rather than gathering it in person. So for a few years, we did reduce the amount of audits we conducted, and we used that as an opportunity to invest in training for our staff. Right around the same time we couldn't travel, a lot of educational providers started providing more training online, and we were able to utilize that extensively for our staff. So our workload has remained, the ability to do the audits is now returned, so now we no longer have any travel restrictions, and we're able to go to assessees' locations and do those in-person audits again. So our staffing levels have remained the same throughout the pandemic level. So now that we're back to in-person audits, we're able to absorb that workload again without really changing any of our priorities elsewhere. So we did use that opportunity to invest in training for a few years. As far as anything we've observed, we do see that more and more of our assessee partners are working remotely. That's proved to be a little bit of a challenge for us. In-person audits might not be needed as much in the future. Even before COVID-19, we were doing more and more exchange of information electronically anyway. We do prefer having the ability to do an in-person audit, having the staff there and working through issues with them in person is advantageous in my opinion. But that's really the only changes that we've seen is we've shifted at BoE to a hybrid workforce, and a lot of our assessee partners have as well. So we do have to make some adjustments for that.
But in terms of staffing, we comfortable, or we could probably use a few more, no?
Well, I mean, I don't think anyone would complain if we had
I know they
extra
wouldn't.
positions. But I think our staffing level is sufficient to handle the workload, yes.
Yeah, I was curious. Well, thank you.
Of course.
Oh, yeah, Vice Chair Lieber, go ahead.
Small comment, and I always do enjoy the LTAs, so thank you so much for those. And, in your travels on the agricultural incentive zones, my understanding from when it was enacted was that the counties had to take action to create the zone. And so I've always been kind of curious, are there counties where the county just doesn't take action and there are community orgs that want to be able to avail themselves of that? So if you see something in your travels,
I'll let you know.
thank you so much.
Of course.
Thank you. I think that's it. Unless there's other. We good?
Yeah. Thank you.
Ms. Cicchetti, what's next?
To correct my error, we are
We gotta
going
go back
back
to
to item 13. Item number 13 is Taxpayer Rights Advocate Office Report, update on activities of the Taxpayer Rights Advocate Office. This item is being presented by Ms. Thompson.
How could you skip Ms. Thompson?
I know.
That's what I was thinking.
She's been sitting there patiently all this time.
I don't know.
First, I thought maybe she was saving the best for last, but then I forgot Ted was after me, but that's okay.
Welcome.
So, anyway, good afternoon, Chair Vasquez and honorable board members. I'm Lisa Thompson, the Chief of the Taxpayer Rights Advocate Office, and I am pleased to be here to share with you the activities of the TRA office. And first, I'd like to share with you some statistics on the number of completed cases that we did in the Taxpayer Rights Advocate Office last month and provide some insight on the types of those cases. This month, attached to the PAN, is a memorandum from our office that outlines the number of completed cases and resolved cases. Figures are provided by board member district, by category, and by topic area within those categories. So for August, we completed 22 cases. 5 were in board member Gaines district, District 1, and 3 in board member Lieber's district, District 2, 6 in board member Vasquez's district, District 3, and 8 in board member Schaefer's district, District 4. Of the 22 cases completed, 12 were in the administrative category and 10 were in the valuation category. The administrative category includes topics such as creating and mailing out tax bills, also refunds, penalty cancellations, defaulted taxes, access to data, special assessments, or direct levies on the tax bill. The valuation category includes topics such as change in ownership, declines in value, and appraisal methodology, exclusions, exemptions, and new construction. It also includes general property taxation and assessment appeals. With respect to the administrative category, and it's 10 cases in total. 1 pertained to access to data, 2 involved creating and mailing of tax bills, 2 pertained to delinquent or defaulted taxes, 1 pertained to refunds, 2 pertained to special assessments or direct levies, 2 were in the other category, which had dealt with a tax clearance certificate for a mobile home, and also the property tax postponement program by the State Controller's Office. With respect to the valuation category, and it's 12 in total, 3 pertain to actual enrollment of values, 1 pertained to appraisal methodology, 4 involved change in ownership, 2 addressed exclusions from reassessment, 1 involved exemptions, and the last pertained to new construction. To provide some additional insight on the specific types of exclusion and exemption cases, I offer this further breakdown. Of the 2 cases involving exclusions from reassessment, One pertained to base year value transfer exclusion for persons age 55 and over, and one pertained to the parent-child exclusion. The base year value transfer exclusion case occurred during the time of current law, since the transfer occurred after Proposition 19's April 1st, 2021 effective date for the base year value transfer provisions. The parent-child exclusion case also fell under the provisions of current law of Proposition 19, since the transfer occurred on or after the February 16th, 2021 effective date for Proposition 19's intergenerational exclusions. And the remaining two occurred during that time as well. So, so two of the two exclusion cases were under the purview of Proposition 19. For the one exemption case, that pertained to the disabled veterans exemption. To provide some additional insight on the nature of the cases that our office works to assist taxpayers, I'd like to offer this additional information on a case to show how we help taxpayer. An example that our case helped to resolve involved a taxpayer that unfortunately had a house destroyed by fire. The taxpayer was concerned because almost 2 years after the house had been built, they received a property tax bill for an escape assessment for the partial completion of the construction, and then an assessment as of the date of the completed construction. So the taxpayer felt if the assessor did not assess it immediately, then they shouldn't be responsible for payment of that property tax bill. We explained that the assessor can enroll escape assessments for the completion of construction or partial complete of the construction, as long as it was within 4 years for them to enroll that. We explained that first, before the assessor's office is able to reassess the property, they need to know that the home is rebuilt and what was rebuilt. We also indicated that the time it takes for an assessor's office to go ahead and enroll the escape or completion of construction for that is dependent on how much their other workload is. In large cases where there are many people affected by fires, such as Butte or even Sonoma, there's large impacts, and so it can take time to rebuild again and to be notified of that. So we kind of helped the taxpayer to understand that, and also that the assessor may have waited until both the house and the barn was rebuilt as well before enrolling that, since essentially with the with disaster relief provisions, assuming there is no added new construction or additions, then the factored base year value is restored as it was previously, regardless of the fact that, it's new, as long as it's substantially, the same. So we directed the taxpayer to resources on our agency's website addressing whether property taxes will be increased over what they were before, after basically a person's property is rebuilt following that damage. And there's a frequently asked question that's addressed under the disaster relief category that explains that property owners will retain their previous factored base year value if the house is rebuilt in a like or similar manner, regardless of the actual cost of that construction. It also explains that any new square footage or extras, such as additional bathrooms, will be added to the base year value at its fair market value. So we, again, help the taxpayer understand that there are several factors involved in assessing that property and also restoring the property's base year value once structures are rebuilt following a disaster. And so that kind of concludes my example there of that. But the next item that I wanted to report on is to advise the members on the work completed for taxpayers that spoke or submitted public comments for the August Taxpayer Bill of Rights hearing that was held as part of the August 29th, 2023 board meeting. One taxpayer, Ms. Yang, submitted a public comment concerning assessment appeals, and the taxpayer thought that clarification was necessary regarding the interpretation of Property Tax Rule 326 on reconsideration and rehearing as it pertains to local appeals board decisions. The presenter felt that certain circumstances should be considered ministerial clerical errors where a local appeals board may amend its decision. And at that hearing, I explained that our agency has comprehensive information available on assessment appeals, and that the assessment appeals manual explained that a local appeals board may amend their decision to correct a ministerial clerical error and describe such errors and what they involve. Additionally, I explained that our office found a property tax annotation, an annotated legal opinion addressing clerical errors, and indicated that our office had reviewed the property tax rule in light of the public comments submitted by the taxpayer, and we found that the rule is consistent with the statutory provisions. I also described what our agency's handbook on advanced appraisal said about comparable properties. And during that meeting, I indicated that I would reach out to that taxpayer to direct her to some information defining clerical errors in the context of a base or value transfer to help her understand what can be considered an error to amend a local appeals board decision and to provide information on comparable properties. After that hearing, we contacted the taxpayer and provided information to her to help her understand what can be considered an error and to amend an appeals board decision at the local level, and also provide her with information about comparable properties. The next item that we completed work on from that taxpayer Bill of Rights hearing is another public comment that was also received from Ms. Yang. The taxpayer's comments asked about statistics on appeals, and during that hearing, again, I explained that our agency does publish information on appeals statistics, various statistics that our property tax department compiles after they obtain that from counties, and describe the open data portal where we have that information. And at that meeting, I indicated that I would reach out to the taxpayer to explain where she could find these appeal statistics and do that. So after the meeting, we did reach out to her and direct her to the location of the open data portal so she can gather that information. Another taxpayer, Mr. Hallmark, he submitted a public comment concerning a charge for the San Bernardino County Fire Protection District and a 3% increase. At that hearing, I explained that the taxpayer's concerns was with a special assessment or direct levy and not an ad valorem property tax. I explained that the government code does permit any public agency levying a special assessment upon real property to make an agreement with the county in order for that tax collector to collect the taxes, with, again, the tax bill being a mechanism to collect more than just ad valorem property taxes. So after the meeting, we reached out to the taxpayer, directed him to resources on special assessments, briefly kind of describing what they are and what they're provided for in law, and advised him that he could look at his property tax bill, and it would have the phone number for all special assessment charges where he could call it to get information. Finally, we completed work on another public comment submission from the Bill of Rights hearing, and that was from Mr. Tajarian. The taxpayer's comments asked for assistance to have his outstanding BoE, California taxes, county property taxes, and PG&E bills waived. I indicated that although property taxes cannot be waived, that there is an availability to enter into a payment plan with the county tax collector to, if that money is owed. And also for money that may be owed for the alcoholic beverage tax, and that if it is in collections, that it would be eligible for a payment plan. We also explained that the alcoholic beverage tax itself could not be waived, but it is possible for penalties and interest to be waived, with the taxpayer being able to make a request for that penalty relief online through the filing portal. During the hearing, I indicated that we would contact the taxpayer, let him know where he could get information about these payment plans and requesting relief for those penalties. So we did so. At future meetings, I will provide further updates to let you know additional actions by the TRA office, and I'm available if you have any questions.
Just a quick one. First of all, thank you for your report. And I was happy to hear about your responses to many of the issues, especially around the challenges, I guess, around Prop 19. But what do you think is the most helpful, I guess, the taxpayers whose parents died and they have inherited the home, but they have no idea, I guess, what they need to do to file for that homeowner's exemption?
Okay, so there's a couple things. I mean, our office does not, provide legal advice.
Right.
But in the case where, a parent passes away and their children, are kind of dealing with emotional grief as well as obviously the property, is it's important really for them to know, especially if they're like an administrator of the trust, to either, again, do some research on their own or seek legal counsel. But they can go to the county assessor's website where the property is located. There will be information about change in ownership filing requirements. That's kind of a big thing, because when a decedent owns real property, you have 150 days basically to file a change in ownership statement with the county assessor's office. And by filing that actually can lead that person to understand that there's a parent-child transfer available out there, the transfer exclusion, that could benefit them. Because that's kind of the big thing, is how do they know about it? You have a lot to deal with, and that how you know. So you start doing research and looking at that. And the change in ownership statement, which is COSD 502, I think, but it has a question indicating, if this transfer, is between parents and children, then you may wish to look at the parent-child exclusion. So that's one thing. That exclusion form would have information about, like, to know that they have to file the homeowner's exemption claim within 1 year to receive relief from that date. Although you can have relief prospectively as long as that child lived in it within 1 year as their primary residence. Another area I think that I would suggest for taxpayer is to look at our taxpayers' rights advocate information sheets. They're very good. We have one that addresses transfers between parents and children. In the future, we will also have one actually addressing basically the change in ownership requirements. What happens when you have property and you have a death? What kind of needs to happen? So we'll be developing that. And working obviously closely with kind of legal to make sure we're not pushing over into the legal area. I don't think we will be. It will be pretty similar to the way our structured information sheets are, telling them what the main requirements are and where to find the resources about it. So I think kind of that's an area that they can look at. But call the assessor, call our agency, call board members' offices, and you can direct them to resources.
So it sounds like we don't, like you said, we can't, one, give legal advice, but two, it doesn't sound like we have a whole lot on our website other than possibly maybe a link where they could, because it sounds like it's more they have to really zero in with their county assessor, right?
We have a lot of information on our website,
Oh, we do?
so I wouldn't
Okay.
say that. I would say that, though, for the change in ownership
Right,
reporting requirements, I mean, that would be at the local county level.
right.
So, yeah, I mean, you'd normally, like, if you buy a house, you, as part of escrow, fill out,
Right.
like the preliminary change in ownership report. So that doesn't happen when somebody passes away. So it's whoever, like the trust administrator, or if they don't have a trust, if it will, then it's somebody's, responsibility to report it. So, so those things happen, and that's really the key, is to know that, because at that point, they need to make a decision. If they're going to keep the parents' base, their low property tax base, then a child's gonna have to move into it within a year and make it their primary residence. Otherwise, then they can't have the exclusion under the current law. So I think we have information out there, but there's just many resources, and hopefully people take the time, to do it. Many county assessors' offices already link to, like, our taxpayer rights advocate area anyway, so. And to the board, not just our pages, but I know we have counties that link directly to it, or under their need help area or stuff like that.
Thanks. Are we good? Oh, Member Schaefer has that question.
Thank you. Do you recall Howard American from San Diego? He gave us a public comment. Did he come through your office? Was he one of your eight cases from District 4?
I'm sorry.
Mr. Schaefer, let me just explain. It was a public comment that was received this morning, and I read it into the record.
Oh, that one. Okay, so, yeah, so as Mr. Angel was indicating, so what happens traditionally is that if there is a public comment, like board proceedings would forward it to our TRA office, or even Henry has forwarded it to us, Chief Counsel Nanyo, and then we work with him. So like in this case, so after this board meeting, board proceedings, or Mr. Nanyo will forward it to the Taxpayer Rights Advocate Office, or just to me, and then I'll look at it and see what that person had to say, and then perhaps contact them and try to resolve their issue. I wasn't sure which one that was, but yeah, one of the cases that we completed actually was the one that said they were from San Diego.
The 8 cases that you handled out of my district, did anybody mention they were aware of Member Schaefer, good or bad, or are they just unaware there is such a thing as the members? Are you the only employee they talk about?
So taxpayers can contact board members' offices as well, and then each of your offices might refer a taxpayer to us and ask us to help the taxpayer.
Sure.
Or they might contact us directly. So we're pretty prominent on our website about.
And if they
dealing with
contacted
this.
our office, would we have to refer it to you, or would you just pick up on it anyhow through our staff members?
So if if a taxpayer contacted your office and you wanted us to help the taxpayer instead of, you're welcome to help them yourself if you'd like, but if you wanted our TRA office to do that, then yes, your staff would reach out to
You had one
myself and the TRA
administrative-
office, or even our executive director, and then we would kind of handle it from there. And then after we assist the taxpayer, we would let your office know that we talked to that taxpayer, assisted them, and to know, so you know that that matter is closed.
We had one administrative case that was for a refund. Did the taxpayer get the refund?
I don't know which, I'm not sure which, I'm sorry, exactly,
Well,
what that was.
you know that we're not conducting a hearing here, and we're not deciding anything. We're just getting a report, and we know that you're doing a very thorough and good job. We have not heard any complaints at all, and I want you to know that if you gave us even 30 seconds of each of the 42 cases, that would be a 20-minute presentation. I don't think we need to know about the details of any of the cases unless they are particularly of interest, like Prop 19 cases are particularly of interest right now because it's in the news. And if you had, some very interesting case because it involved bunnies at Easter time or something like that, that's of course entertaining as well as informal. But I'm trying to ask you to realize that we're not interested in a report on the facts of any of the cases that you do such a good job on. I would like to hear from you about the top 5 maybe, and that would be about it, because as you realize, we have long agendas here, and some of us have been up since 5 o'clock this morning to come here and save the taxpayers. Okay, thank you.
I give one example. For this meeting, I gave you a little bit more information because I thought it was important to highlight that we completed those cases that came about basically from the August Taxpayer Bill of Rights hearing. So for the next few months, I will be having another, couple more examples just to let you know how we help those taxpayers that came before us.
I
And
know you're helping the
Yeah.
taxpayers, you're doing a very fine job. It's that I don't need to know everything you're doing because I can go to our website and, look up whatever I want to look up. I don't need a duplicate presentation, but I do commend you for all you're doing. I just want you to know that I'm interested only in your most interesting and most relevant cases and not in the other 75, which it's very important, the work that you do, and I commend you for it. Thank you.
Thank you. Any other questions? Thank you.
The next item on the agenda is item 15, Legislative Research and Statistic Division Chief's Report. Update on administrative and program-related legislative bills impacting the BoE. This item is being presented by Mr. Angelo.
Okay, I'm back.
By popular demand.
Chairman Vasquez and honorable members, again, Ted Angelo, Chief of the Legislative Research and Statistics Division. Today, I'll provide a summary of the bills we're following that could impact and will impact BOE's tax programs and administration. The legislature adjourned on September 14th, at which time the legislature will be in interim recess for the 2023-24 legislative session and will reconvene on January 3 of next year. The governor has until October 14th to sign or veto bills. So, and that's unless they call a special session for any issue that may become of interest, and there is some concerns about insurance happening right now, but we don't know if a special session will be called. Of the 32 bills that we've been closely tracking, 19 have gone to the governor for his consideration. I continue to send weekly updates on the status of those bills. I just sent one last Friday. There hasn't been much action on those bills yet, except for the one that we covered today on Bagley-Keene, which was recently signed. SB 20, which I'll cover a little bit, was signed earlier this month. That was board supported. So today I'm going to cover a little more in depth the board sponsored and the board supported bills that have gone to the governor. So for BOE sponsored legislation, and I've given updates on these before, they are both on the governor's desk, and they are the omnibus tax measures that are BOE and CDTFA, and in some cases FTB related tax issues that the Senate Governance and Finance Committee has carried on behalf of us. So SB 889 has been sent to the governor, and this amends Section 32-387 of the Revenue Tax Code to authorize electronic service of levies. It amends Sections 32401 and 32440 of the Revenue and Taxation Code, requiring any determinations or cancellations made by the board under the alcoholic beverage tax program that are in excess of $50,000 to be made public for 10 days after the effective date of the determination or cancellation.
Excuse me, before we leave that, could you estimate, do we ever have determinations under the alcoholic beverage tax? I was of the opinion that maybe once in a few years.
I don't have the statistics in front of me on that. This just was a board-sponsored technical cleanup proposal, so I don't have statistics on that today, but we can reach out to your office with that.
Well, I was just wondering if it was a problem, why would we need, I mean, if it's not a problem, I'm questioning why we have a law, but I guess that would be a question I'd be taking up with the sponsor rather than us, because we're just the recipient of the law.
This is Lisa Renati, Chief Deputy Director. Mr. Schaefer, this is one of the board-sponsored bills that this board has sponsored. It's a technical change, and it just allows I think this is the one for the refunds, allows the taxpayers to get their money sooner. And this is for refunds that are in excess of $50,000. So they do happen occasionally where a taxpayer has overpaid and gets a refund, and this allows them to get their money sooner.
Well, that's good. Do we have a handful of these every year, or?
I'm not sure if it necessarily is with the alcohol program. This is going to follow all the special tax programs that CDTFA and BOE handles. This is specifically for alcohol.
Yes, and I've been here 5 years and I haven't seen any alcoholic beverage tax program cases that I can remember.
Well, and these would not be cases that would come before the board. This would be a refund that's being processed to give back to the taxpayer.
Sure. All right, thank you.
So there are, in both of these bills, there's technical cleanup provisions for code references that needed updating and things like that as well. So SB 890, and then in terms of electronic transmission on alcoholic beverage-related tax issues, there are some proposals that could be coming forward next year that we will be discussing with the board that were not included in these bills because there was some concern about provisions in them that could potentially lead to penalties for noncompliance, even though it's permissive, the electronic transaction provision. So those will be coming before you for consideration next year in technical cleanup bills, but they're not included in these two. The second bill, SB 890, is a technical change regarding the implementation of Prop 19 that amends sections 62.1, 62.5, and 69.4 of the Revenue and Taxation Code to include references to section 63.2 relating to the intergenerational transfer exclusion and 69.6 relating to the age 55 and older disabled disaster base year value transfer. Again, technical cleanup sponsored proposals that I've been updating you on this year. So those are those two. And then the next that I'm going to go over with a little more detail today are the board-supported legislation. So on the board-supported legislation, I've been sending the support letters that I forwarded to the governor on behalf of the board, the elected board members. So the first one on my list today is AB 556 by Assemblymember Gallagher, which is on the governor's desk regarding the transfer of base year value. It relates to the property tax law, which provides that the base year value of real property that is substantially damaged or destroyed by a disaster may be transferred to a comparable property located within the same county that is acquired or newly constructed within 5 years after the disaster as a replacement property. This bill would extend that by 3 years. And if the property was substantially damaged or destroyed by the 2018 Camp Fire disaster, as proclaimed by the governor. So it's an urgency statute. It would go into effect immediately upon signature, and that's on his desk. The next bill is SB 4 by Senator Scott Wiener. That's gone to the governor regarding planning and zoning and housing development. This bill requires that a housing development project be a use by right upon the request of an applicant who submits an application for streamlined approval on any land owned by an independent institution of higher education or religious institution on the date specified, if the development satisfied specified criteria, including that the development is not adjoined to any site where more than a specified square footage on the site is dedicated to industrial use, and other technical provisions that provide protections for such approval or expedited approval. That bill was sent to the governor on the 15th of September and is awaiting action. And we sent a support letter, and I copied you with that letter. That one specifically, we referenced on behalf of the elected board members that SB4 would make building affordable housing easier, faster, and cheaper for faith-based institutions and nonprofit colleges that desire to do so. So I'll stop there, but you've seen the copies of the letters I've sent on behalf of the elected board members. The next bill, let's see here, is SB 20, and this bill was signed into law, and I've copied you with a letter. It authorizes two or more local agencies as defined to create a regional housing trust for the purpose of funding housing to assist the homeless population and persons of families of extremely low, very low, and low income within their jurisdictions by entering into a joint powers agreement pursuant to the Joint Exercise of Powers Act. It authorizes a federally recognized tribal government also in later amendments to enter into a JPA as well. That bill was signed by the governor earlier this month. Again, these are board-supported proposals I'm referencing right now.
Mr. Angelo, on SB 20's, Senator Rubio's bill, I'm familiar with the term low income, but I haven't seen very low or extremely low. Could you quantify those amounts? Do you have any idea what they're talking about? And also, would that be would that be the same as homeless population? I would think your homeless population would be the same as the families of extremely low.
I don't have the statutory references in front of me regarding extremely low, very low, and low income and what those thresholds are.
And whether that includes the homeless or not? Or is that a separate category, the homeless?
I don't believe so.
For the most part, you're using 80, I think they're using 80 AMI.
I believe so.
Yeah. And very low, I think, would be down to like maybe 60, and then very low would be like 40.
But we
Now,
have.
some, they get adjusted because some are, HUD has different restrictions, right, when you're dealing with the feds.
Yes.
But the state, that's usually what the state has.
And that's families, that's everybody in the family.
Right.
Yes. All right, well, that's good. I just haven't seen extremely low used before.
Right. And
Thank-
to be honest with you, the low income housing tax credit laws and all the changes that have gone for the different types there's about 7 or 8, and then some specialized ones that Mr. Young has talked to you about before. We're probably not going to go into that today, but there is a significant statutory framework for these different types of federal and state-based low-income housing statutes that work in concert with one another. Some have special requirements, and some are for single-family homes, and some are for multifamily homes, some are for mixed use, where there's low to moderate income in the same unit. So it is a kind of a complex web. To try to explain it in a hearing like this would be difficult, but I appreciate the inquiry, and we can find that answer for you.
Thank you.
Yeah. The next bill is also by Senator Wiener, and it's SB 423 that the board supported. And it's regarding streamlined housing approvals for multifamily. The board supported this bill because it will help expedite the building of more affordable housing in California. It streamlines and expedites the ministerial approval process first established under SB 35 by Senator Wiener in 2017 for multi-unit housing in cities that are falling short of their regional housing needs allocation, and extends the current sunset date by 10 years until January 1, 2036. Among other technical changes in the bill, SB 423 will also require that jurisdictions not meeting their housing targets for above moderate households, projects eligible for SB 35 streamlining must contain at least 10% of the units affordable to very low income households. So that term's used again here, as specified. It also would authorize SB 35 statutory requirements to apply to the coastal zone beginning in January 1, 2025. So it has a delayed implementation of that, but be consistent with the applicable local coastal plan or land use plan, except in areas that are environmentally sensitive or hazardous as specified. 3, it specifies that SB 35 streamlining shall not apply in specified fire hazard zones unless sites have adopted all applicable fire hazard mitigation measures as specified. And it makes some other clarifying changes. So it expands this ministerial approval process, but has some safeguards in place for those that I just referenced. That bill has gone to the governor for action as well. The next two sure I'm not missing one. Oh, so the next one I'll cover is SB 588 by Senator Allen. That bill was held and it became a 2-year bill. It's in the Revenue and Tax Committee, and it provides that property that is used exclusively for rental housing and related facilities that is owned and operated by specified entities, if any of the specified criteria are met, including that 90% or more of the occupants are low-income households. It provides that the claimant is liable for property tax for the years which the property received the bill's tax benefit. This bill had some controversial aspects to it and was heard and became a 2-year bill. So it cannot be heard until, session resumes next year. SB 734 by Senator Rubio provides that all existing law requires that all property subject to tax be assessed at its full value and includes certain possessory interests among those property interests subject to the tax. Possessory interests in a tenancy in a residential unit of a publicly owned housing project by a low-income household or affordable rents does not create independent possession or use of land improvements by that tenant. So SB 734, which we supported, kind of codifies legal standing that we've had and that the board supported, that there shouldn't be a possessory interest assessment to folks living in these low-income house provisions. That's gone to the governor, and we're awaiting action on that one.
What's the number of that again? Was it 44?
It's SB 734 by Senator
734. Thank
Susan
you.
Rubio. The next two bills, I'm not going to go into full explanation of because they deal with the same issue, but they are SB 871 by Senator Archuleta and SCA 6, the constitutional amendment by Senator Archuleta regarding the veterans exemptions. So these are issues that were on the last day of session. SCA 6 was sent to the Assembly, where it would, in my estimation, still have to go through the committee process unless they did a waiver and did it off of the floor, which they didn't do. But these are the ones that would authorize the legislature to exempt property for the veterans exemption, in addition to the homeowners exemption. There's costs associated with these, so they're being reviewed, I think, more closely. And so we'll be tracking those closely for next year. And SB 871 would be the operative legislation that is the non-constitutional aspects of any changes that those would put forward. So that's why I've tied them together here. So the bill, SCA 4, was held and didn't pass, but was granted reconsideration earlier this year. It ends specified provisions of Prop 19 for the change of ownership and brings the law back to where it was before. That bill failed passage and reconsideration was granted, but this is the one I covered in previous meetings where the Howard Jarvis Taxpayers Association put in the similar language and went to the AG's office, and it qualified for circulation, was clear for circulation, and is currently in the signature gathering phase. They need approximately 875,000 signatures by February 20th of next year in order for that to qualify. So that's my summary of the bills that were supported by the board. And again, I've sent the letters that we've supported to your offices and staff. Lastly, ACA 11, as we all have been tracking, is not moving until there's no activity. We're tracking it very closely. There's been no updates since my last update on where it is, but that bill could still possibly be heard. Not bill, constitutional amendment could possibly be heard next year if the author decides to pursue it. We haven't heard any updates on whether or not that's the case, and the committee consultants that I've spoken to haven't heard anything about any intentions to do so, but we'll keep your offices updated. So again, all analyses with very detailed policy and fiscal breakdowns are available on our website for all the legislation I spoke to today, as well as those that are on the list of the 19 that have gone to the governor, which I'm not going to go over today unless you have specific questions on one. I have a list of those that have gone there. That concludes my legislative update, and I'm happy to answer any questions you may have on those measures or any that I didn't reference today.
No, thank you for your complete report. I know you didn't get into all of them, but it looks like we did pretty good overall, at least the ones that we
I think so.
supported.
I
I
think
think there's
so.
only a couple that were carried over as two-year bills possibly.
Yes, and
Which still means they're alive, but.
it still means they're alive, and when you're getting into issues like that have significant costs, it's especially coming out of a budget shortfall. It's hard to push more like that. Hopefully, we'll get some good news as the tax filing deadline comes in.
Right.
And things aren't looking quite as bleak. I mean, it's not a horrific situation based on how big the general fund budget is these days. But a $30 billion shortfall in a $300+ billion general fund budget is still significant. So it's going to give them pause when you have proposals that are well-intended and have the costs associated with them. So they still have a chance next year, and if not, they'll have a chance the year after that.
No, thank you. I don't see any comments. I think we're good.
Thank you.
Ms. Cicchetti, I think we're at the end, no?
We are at the end of the items for the agenda for today, correct?
So, just in closing, I was just going to mention, it was brought to my attention that today is the National Assessors Day. Today, property assessors perform meaningful work to help communities thrive and grow. Fairly valuating every property is important work that is often overvalued or goes unnoticed. We thank and appreciate the hard work our assessors do. I believe our San Diego, I don't know if he's still here, our San Diego assessor, Jordan Marks, is here with us. I know he'll be here with us tomorrow as well. And I just wanted to personally wish him and a happy National Assessors Day, along with the Los Angeles County Assessor Jeff Prang and all the other assessors who may be here today and I will be joining us tomorrow. And I know we talked, well, I think I was going to talk a little bit about the mental health issue, but I know a couple of members already raised that issue. The only other thing that I noticed is that it's also Constitution Day and Citizenship Day. It's part of this whole week from September 17th to the 23rd. And from my understanding, I guess this has been going on for some time. Some of it dates back to 1787. And then most recent, it's been changed. And I think it included Citizenship Day, which began in 1952. And one of our previous presidents, Harry Truman, in 55, proclaimed this as the Constitutional Week. And in the spirit of these observance, United States Citizenship and Immigration Services of the USCIS celebrated Constitution Day and Citizenship Day by welcoming more than 6,900 new citizens over the 130 naturalization ceremonies across the nation between September 17th and the 22nd. So with that, I'd like to just, we won't close it out, but we'll just recess and reconvene tomorrow morning at 10 o'clock.
10 o'clock.
Thank you all. It is 4:23. We ran a little over, but not too much.
We had the fire.
It was about